online, and I will read my legal stuff here first. Recognizing a quorum of commissioners, I call the September 8th, 2023 public hearing of the Cannabis Control Commission to order. This hearing is being held remotely pursuant to Chapter 22 of the Acts of 2022 and is being recorded. Commissioners Camargo, Concepcion, Roy, Stebbins, and I are participating in today's meeting. There will not be any policy votes taken by the Commission today because this hearing is about listening to the public and their feedback from our draft regulations. I will ask the Commissioners attempt to refrain from asking questions or commenting during public testimony section to allow enough time for all people to testify. And again, we're trying to make sure that we can get through this. I think we have close to 50 people who want to testify. That being said, it is a regularly noticed meeting, so if there are some questions for clarification, the commissioners certainly have the opportunity to do it, but I am strongly suggesting that we try to let everyone speak and get through this process. The order of the speakers is subject to the chair's discretion. For the most part, in-person elected officials will speak first, then in-person speakers, followed by elected officials joining remotely, and finally, virtual speakers. In-person speakers who did not sign up before today can do so via form stack with the help of commission staff. In-person signups received after the start of the hearing will be added to a list and given the opportunity to speak if time allows. Those unable to provide oral testimony due to time constraints will be asked to submit written testimony to, and this is the email address, commission@cccmass.com, and I'll repeat that, commission@cccmass.com. For the testimony via email, the public comment period closes at, it's 5 o'clock today, correct? 5 o'clock today. In-person speakers, when it is your turn, please come to the podium or table and speak into the microphone. Virtual speakers will have their cameras and microphones turned on when it is their turn. We ask you, please be respectful, remain muted until it is your turn to give your testimony, be mindful of the 3-minute allotted time, and stay on topic. Your testimony should be related to the draft regulations. The Commission does not support discriminatory or offensive language. As chair, I reserve the right to stop the testimony and ask that you submit written testimony. Because of time constraints, this meeting shall conclude no later than 4 p.m. And we will get to the next meeting. And so with that, let me just make sure that's here. So we will begin with Senator Michael Moore is first up. Senator Moore. Oh, sure, please. Hold on.
Sorry, good morning, Senator.
Can we request no chairs? Because this is, having been at the State House, never served with you, it enhances more rapid delivery of testimony. So anyway, thank you. So, my colleagues. Thank you. Just one moment.
Sorry, Commissioner. So before we begin, I just want to ask Madam Chair if we can request those who come up to testify to state sort of the subject that they're testifying on behalf of. Because I think we're all taking notes and just will be easier going forward.
Okay. All right. Thank you. Sorry, Senator Moore. Thank you.
Right. Senator Michael Moore. I'm speaking to the change in the regulations that on the, I guess, the hiring requirements or prohibitions. So good morning, Commissioners. Thank you for the opportunity to testify on the proposed regulatory changes. I greatly appreciate the time and effort you and your staff have put into drafting these regulations. My testimony today follows up on a letter I sent to the CCC in early August on the impact of the proposed changes that the proposed changes will have on the agent suitability standards and the potential for sex offenders to become retail or delivery operator agents. As you know, back in 2017, the CCC first implemented the current mandatory indefinite disqualification on those who were convicted of a sex offense from obtaining registration as an agent. As a rationale for that decision, the CCC observed that the retail agents have direct access to customers and their personal data. Because of that level of access, the CCC determined that the retail agents should be subject to higher suitability standards. The draft regulations before the CCC abandon that higher standard. This change under consideration would also allow operator to deliver operator agents. I think it's unfair. I think it is fair to say that no one should have to open a door or their door to a registered sex offender. Also, the change that was made legislatively to the standards allows for the prohibition of a minor, someone who was convicted of the distribution of a controlled substance, including marijuana, for being employed in one of these positions. But it doesn't restrict someone who could be a level 3 sex offender from filling one of these positions and actually going to someone's house and delivering the product. I find that a horrendous loophole in the law, the fact that we would possibly allow a sex offender from a level 2 to level 3 to actually go to the premise of someone who could have been convicted of raping a child, raping a woman, or just rape in general, or some sexual offense. While I generally support removing barriers to entry for employment in the marijuana industry, I believe that certain safeguards need to be maintained. I am asking the CCC to consider a mandatory, indefinite disqualification for individuals required to register as a sex offender for agent suitability. Whether someone is required to register and their classification level is the decision made by the Sex Offender Registry Board, and that decision is an independent civil determination made by the board outside of the criminal process. This prohibition already applies to individuals who hold a license, and I ask that the CCC apply the same prohibition to agents of a licensee. I understand that the CCC intends to rely on a catch-all provision to protect the public health, safety, and welfare. I'd like to know what that means if there's an issue with not being able to look at someone's criminal conviction. However, this catch-all has several shortcomings. First, it's independent on complete and accurate reporting by the employer during the agent registration process. Second, it is subject to agency discretion, and it's unclear that the CCC will actually use it to exclude those required to register as sex offenders. Finally, it is limited to the preceding 5 years. As a result, if someone commits an act that possesses a risk to public health, safety, and welfare, but it occurred outside the 5-year window, the catch-all will not apply. The CCC should also consider strengthening the catch-all provision in its application. And just to reinforce my position on the civil process aspect of this, if you go to the went on the website this morning for the SORB, and there's a sex offender classification process. And clearly on the first page of it in the preliminary classification, there's one section that says the board, this is the Sex Offender Registry Board, the board member then issue a preliminary classification level recommending the offender be a level 1 low risk, level 2 moderate, level 3 high. The level speaks to the danger and risk to reoffend. To me, I think that goes to the catch-all, that you should be able to apply the standard so that they will be indefinitely prohibited from these positions. Also, in the classification hearing section, there's a section that says the hearing is conducted by a single hearing examiner who may also be a board member. The hearing examiner takes an independent view of all the materials and the factors to be considered. Unlike the criminal process, clearly showing this is not part of the criminal process or the conviction, the Sex Offender Registry Board hearing by law is not open to the public, including victims. There's also a section again, going to the catch-all phrase, we have a section in the level or the levels of the sex offenders. There are 3 levels of sex offenders in Massachusetts. Offenders are classified based on their risk of reoffending and the degree of danger they pose to the public, which again, I think fits again into the classification, the catch-all for public health, safety, and welfare. Then it goes, a sex offender is a person who lives, works, or attends in school in Massachusetts, has been convicted of a sex offense, has been adjudicated as a youthful offender, or as a delinquent juvenile, as a sex offense, and the important thing here, been released from incarceration, parole, probation, supervision, or custody of Department of Youth Services for a sex offense conviction or adjudication, clearly taking it out of the criminal process.
Senator, if I could just, only because we're holding other people, and we've given, out of courtesy.
Okay. Yep, nope, thank you very much.
No, it's been very, and one of the things I wanted to ask you before you end your written testimony, because I know that there's some issues of sort of the legal nuances here. If you have a legal brief that you could share with the commissioners, so we could have benefit of the legal arguments that you're making, because I do know that there, are some questions, on the sort of the legal nuance of this. If you have a brief that you could share with us, that would be helpful. And I don't know if you have that available.
We don't. We just actually, after the letter, we just prepared this
Okay.
testimony for you.
Okay, all right, please, thank
I
you.
know questions we're trying to keep to a minimum,
Yeah.
but this is a serious topic, and I
Right.
do have a couple. And Senator Moore, thank you for your testimony today. In light of the current statute, does the CCC have the legal authority to prohibit individuals required to register as sex offenders from serving as retail or delivery operator agents in light of the statute?
Well, I think yes. The CCC under Chapter 94G has the authority to set minimum standards for employment. While recent legislative changes have changed the option and removed the option, most cases of utilizing a prior criminal conviction or other criminal case disposition as a basis for the disqualification, the CCC can still base disqualification on the Sex Offender Registry Board's independent determination as part of the civil process. So, just basically.
So in your opinion, yes?
Yeah.
Okay. Does this type of exclusion exist anywhere else that you're aware?
Yes, you also have, if you look at Uber, Lyft, some of the other gig economy type of jobs, they all have these restrictions in there, that they run criminal history checks, and they do a sword check, which is also separate from the criminal history check. Further, I think further supporting our argument that this is a separate process from the criminal conviction.
Okay, and I just have one more. Thank you, Madam Chair, and thank you, Senator. With the public health, safety, and welfare, that catch-all phrase, would it address this issue?
Well, I think it could. If it doesn't, then I really don't know what that phrase could be used for then. If you got that for public health, safety, and welfare, and I just referred to the language that's in the SORB website as far as their process and the classifications, and it talks about risks to the public and danger. So if that catch-all language does not apply to what I'm talking about, then I would ask you, what does that language apply to?
Okay, any further questions?
Thank you.
I just want to say thank you. I know you've been really attentive to the work that we've done here at the Cannabis Control Commission, and it's a topic that I read your letter thoroughly, so I appreciate your input. I just want to say thank you.
Thank you very much.
Thank you very much, Senator. Anybody else? And again, obviously, this is, I think you have done a great job in following up on this issue, and we appreciate your time, and thank you for sticking to our time rules. We appreciate that.
I tried. Thank you.
Thank you.
Thank you very much.
Thank you.
Again, next up, we have Nicole LaChapelle, the mayor of my hometown, East Hampton. I don't see her here. She's not here. No, okay. Sean Suhosky. He is the town manager of Athol, but more importantly, the son of my seat mate in the legislature many years ago.
How are you?
Good morning.
Madam Chair, members of the commission, what a great morning, huh?
Thank you.
I'm writing a sternly worded letter to the air conditioning vendor. I'm Sean Suhosky. I am the town manager in Athol. We have 11 enterprises that have gone through local approvals, and I'd say 4 or 5 of them have been through the licensing approval. The others may be pending before you. My position today, I've submitted written testimony on a couple of occasions, and also in my prior capacity as chair for the Small Town Administrators of Massachusetts. The concerns that I've heard from my colleagues are that the goalposts are being moved. It's an after-the-fact rules that are coming into effect that would affect our contracts that were negotiated in good faith, and many times with corporate interests that have budgets that quintuple the size of the entire town budget. So this is arm's length, if you want to call it that, negotiations, mutual agreements and contracts, and we're very concerned in looking at the draft regulations that all of these contracts, which would have sunsetted in 5 years anyway under the prior law, now will be subject to a state agency review for new rules, to comply with new rules. My point today is that cities and towns need a predictable off-ramp from these contracts. So does the industry, so does your commission, right? Wouldn't that make life a lot easier than wondering if we're going to have 600 lawsuits? I feel that municipalities were painted in a bad light because of a corrupt mayor that makes headlines everywhere. Well, that's not the colleagues that I know. That's not what local officials that I am familiar with do. They're looking to stimulate business, but there was also a bargain for exchange. These communities, Athol included, and my elected board included, did take the promise of an economic benefit, and our staff then went through a process to develop an application procedure, amend our zoning bylaws to welcome an industry that was previously illegal in the Commonwealth, still remains at question at the federal level. So I just want to speak up for cities and towns and say, if there's something in the old contracts that's unconscionable, anybody can sue us. You know, there's a couple lawsuits pending. We should not be changing the rules after the fact. And I want to add one more piece to this. We had a state senator just spoke. Before enactment of Chapter 180 of the Acts of 2022, there was a House, obviously, many House versions, many Senate versions, and as they come together before they get enacted, there was a specific piece of language. It was the last sentence in the language. This law will become effective, and it was going to be retroactive to 2016. The legislature took that language out in the final bill, in the final law that was signed. That tells me the legislative intent was that this not be retroactive, and I've seen other correspondence from state legislators that you have as well that will back that up. Aside from that, we have some great operators in Athol, and I'm very curious and pleased to see the commission working so hard on a new industry to come up with the equity provisions. We just need to protect the contracts or find an off-ramp for all of them, for the cities and towns as well that are hosting these facilities. So thank you very much for your time.
Appreciate it. Thank you, Sean. Thanks very much. And again, I'm going to try to keep us to the 3 minutes. You were good, but just making sure everyone knows that tiny little like minion looking thing there is the timer. And so that's what you need to kind of keep an eye on. And when I start looking like this, just understand I'm panicking.
Madam Chair.
Please.
Just maybe to use the baseball analogy, as you call up the next speaker, maybe notify
Yes,
who's
I
on
will.
deck,
Yep,
who's grabbing a bat in the dugout.
Oh, I
can
can't
use that.
imagine you raising a baseball analogy. Thank you very
And
much.
Madam Chair, may I also add, if folks could lean into the microphone and speak, you see the difference?
Yeah.
So if you could do that, I guess some folks are having a hard time hearing you virtually.
Hold that down at all? I don't know. Does it make sense to maybe pull it a little closer to the front? Is it taped on there?
Is it on?
Because I'm a short person and that,
Yeah.
well, that might. All right, thank you. Next up is Ali DiMatteo. And on deck is Shalene Title.
Thank you
Thanks,
so
Ally.
much. Thanks for having me here. It's good morning, everyone. My name is Ally DiMatteo. I'm a legislative analyst with the Massachusetts Municipal Association. Thank you so much for the opportunity to testify before you today on behalf of cities and towns regarding CMR 500 adult use of marijuana draft regulations. As you know, I'm joined today in person by Sean Sahosky and remotely by Mayor Paul Broder, Mayor Lungo Kern, and Town Administrator Douglas Lapp, who will all be testifying virtually. First, I want to be clear that the MMA and those here with me and the many municipalities who have recently sent letters on these draft regulations share your goals in creating statewide equity in the industry while allowing it to continue to grow. We see good intentions behind these draft regulations, and I really believe that we all want to get to the same place, but we do not see these draft regulations as the way to get there. We are continuously frustrated by the language, the retroactive language in the regulations, subjecting hundreds of existing HCAs retroactively, despite being negotiated in good faith. This was not the legislative intent of the law, and I know that several legislators have already submitted and reached out to the Commission to clarify that. The Commission has the opportunity, a choice, to address this and accommodate existing HCAs, allowing them to sunset while also ensuring new rules moving forward adhere to the changes of Chapter 180. Oops, sorry, I lost my notes here. However, if the Commission moves forward as is and actively chooses to forego a two-tier approach, do we think it'll catalyze the Commonwealth to meet the shared goals of equity in the cannabis industry? I don't think so. It would welcome extensive and costly litigation. The contract clause of the Constitution is clear, and we anticipate having this issue continue in the courts will only set back the gains we are all committed to in the industry to right the wrongs of the war on drugs. This will instead hinder the growth of new licensees, stifle equity, and only help the current multi-state actors who currently dominate the industry. We've submitted extensive comments as well as a redlined version of the draft regulations, and I'd be happy to have further conversations on this issue. I know you come with this with good intentions, but we urge you to fully consider our concerns very carefully. Again, we share your goals to promote equity in the industry and believe there's a continued opportunity for it to flourish in Massachusetts. I ask you consider the comments of myself and my colleagues as good faith actors who have embraced the industry and want to see that relationship continue. Thank you.
Thanks so much, Ally. Thank you. And Shalene, and then after Shalene Title is Grant Smith Ellis.
Good morning.
Hello, good morning.
I'm Shalene Title. I'll be speaking about municipal equity. I want to say first off that I thought the draft was very thoughtful and very well done overall. So kudos to you and to your staff. I want to talk about municipal equity because I think there are a couple of simple to address but critical issues. And I've met with the chair and Commissioner Concepcion about that. I've submitted written comment as well, but I do think they're critical, so I appreciate the opportunity to address you all formally in person. So the first thing is that for cities and towns that are not presumed compliant under the regulations, they have to create an equity plan, goals, programs, measurements, all appropriate. But what's missing is a process to review and approve those plans initially, as well as every year or periodically to make sure that the data is being collected and the plan is proceeding. And I think it's very important for the public and for municipalities that are watching this process to be able to observe this. Secondly, I think the presumption is excellent. That is totally consistent with my 5 or 6 years of talking to municipalities, as the previous speakers have said, they share these goals. And I've heard a lot that they just want some guidance, right, and some clarity. And so I think that if you are able to provide a model ordinance rather than describing the ordinance as in the draft, you can define some of these terms, you can provide some consistency and clarity. I think it would also be a lot of work to review every ordinance and bylaw and see if it's matching up with the way that it's described in the draft. I think also a model ordinance could provide some consistency for data collection as well, and you'd be able to compare into the future, and it would be great for the research team, I think. And then finally, this is a small but important tweak. So under the presumption, there is a one-to-one equity basis that's described. And the way that so it's general versus equity, the way that the equity applicant is measured is described as a local approval process being completed, but that isn't defined. And I think it would cause a lot of confusion if that's being defined in different ways. So instead, I would recommend measuring it by when the equity business commences operations, because it's clear, it's consistent, and you have access so you can verify that date as well. And I think that would help both the one-to-one basis and the presumption to be more effective. So those are my changes. Again, thank you so much for your work and the opportunity to speak.
Thank you so much. Grant Smith Ellis, and after Grant Smith Ellis is Matthew Duncombe. And again, if you could sort of start making your way when you see the little yellow part of the minion there lighting up.
Hello, Commissioners. Thank you very much for the time today. My name's Grant Smith Ellis. I'll just say I'm here in my personal capacity, and yes. How about that? Yep. Okay, I just can't bend over that far. Thank you for the opportunity to be here for today. I feel a little bit like Commissioner Stebbins, and then I can say I'd like to echo everything that former Commissioner Title and Senator Moore said, so that gets that out of the way. But I also want to importantly echo that I do think that the process that led to the development of these draft regulations was deliberately done in a way that was informed and in line with the statutory requirements. In particular, in regards to host community agreements, I think it's important that the public and everyone involved with this process understand it wasn't just one bad actor in Fall River. Subpoenas went out to a number of cities and towns about their behavior related to the HCA process. And because of a single vote in, I think it was 3-2 in September of 2018, this commission was not reviewing those host community agreements for compliance with the law during a period that was no less than 36 months. So for cities and towns to now say, well, don't look back at that 36-month period, those were just freely negotiated contracts protected by the Constitution. No, they were contracts negotiated sans oversight by any level of elected or appointed state government in the Commonwealth of Massachusetts. And they absolutely should be reviewed. And if you don't want them to be reviewed, cities and towns, I want to know why and what you're hiding, which further incentivizes reviewing them. Going forward, as to the agent suitability provisions, I'm reassured by what I heard in the colloquy between Commissioners, the Chair and Senator Moore earlier regarding the catch-all provision. And I do think Senator Moore makes a very strong point about the ongoing nature of the civil determination as to a sex offender's status. So even if the catch-all provision is limited to 5 years, that status has not gone away and is perpetual. What I am concerned about, though, is whether the catch-all provision would cover an unregistered sex offender, because I'm not sure specifically whether the failing to register is a civil or criminal issue, and clearly failing to register should be considered just as serious a threat to the public health as ongoing registration. And I'll end there. Thanks very much for your time.
Thank you. Matt Duncombe. Matt Duncombe. Is he here? Matt Duncombe. Going once, going twice, if Matt is not remote. Anyway, next is Lucas Thayer, and after Lucas Thayer is Alyssa Noah.
Good morning, Commissioners. Thank you for hosting this hearing. Thank you for hosting me to speak. My name is Lucas Thayer. I'm a Tier 2 outdoor provisional license applicant. I'm also in the social equity program. I think it's a cohort number 2 that I was in. And HCA's are extortion, the way that they're put together right now, the way that municipalities bully operators, whether it was during that 36-month period where they weren't being reviewed in what they were doing or afterwards. It's too much what municipalities require. It's also too much for operators to be required to pay rent at their facility for months and months and months and months, a lot of money, with no plants in the ground and no money coming in, just to get that and the architectural review and the final license and the commence operations. All that stuff is months and months and months of rent that goes towards the cost of the operation, but really it gets passed on to the consumer. The consumer is the one that pays those months and months and months of rent. That's why the stores have weed that's too expensive right now. That's why the public laughs at the idea of the stores and their weed, which is too expensive, because all these people have been paying so much out in rent and lawyers' fees and architectural review fees and site design fees and fees for the fact that you had to pay the fee. There's way too much barrier to entry in this industry, especially for social equity applicants and economic empowerment applicants. The legislature mandated that you folks give SE and EE operators a leg up in the industry, and that's just not the case. The delivery, the two driver model needs to go away. I'm sure we already talked about that. We all feel that way. Social consumption, I think I mentioned to you and you at the last hearing, the social consumption license needs to have an exclusivity period of 10 years, not 3 or 5, for EE and SE applicants, because as I said at the previous hearing, it takes multiple years to get up and running. It'll take multiple years to get up to zero, even breaking even, and then it'll take multiple years after that to make anything that even resembles a profit. Looks like, do I have more time?
You got
Great.
1 more minute, yep.
The community impact fee should not be 3%. I think it should be 0, but maybe drop it down to at least 1% maximum, because really cannabis businesses don't cause a financial impact to communities. So that's just more extortion. And also, please don't allow sex offenders to work in the industry. I think we've already talked about that, but I reiterate that as well. I'll yield my time. Thank you.
Great, thank you so much. Thank you, Lucas. Next up is Alyssa Nowak, and after Alyssa Nowak is Devin Alexander. And if you could kind of tee up before the next person comes up. Thanks, Alyssa.
Hi, thank you. Thanks, members of the commission, for having us all here today to hear our comments and all the work that you've done on the draft regulations. The intent was great, and I'd just like to make a few comments. As a Cohort 1 social equity participant, I feel that the commission should grant a waiver to operators in which host communities are not compliant with the new law and don't want to be compliant with the new law. The commission shall also notify municipalities and their respective council. And if council is not readily available, perhaps KP Law, since they represent a lot of the municipalities in Massachusetts, of the new regulations, and let them know that if the HCA is not in compliance at the time of the renewal, it will delay operators and they will face monetary penalties. Reward municipalities that get the HCA right on the first shot at renewal. I think that's huge. And then also reward municipalities who choose to use the model HCA provided by the commission. Include MOA and MOU in provisions that talk about monetary payments, in-kind contributions, and charitable contributions. Also include MOU and MOA in the explicitly or implicitly a factor considered in a condition of the HCA provisions. In addition to prohibiting host communities from mandating a certain percentage of gross sales, also prohibit municipalities for asking for a flat dollar fee amount. And in addition to the review of HCAs submitted by a marijuana establishment, remove the provision that says if the HCA isn't compliant in the determination notice, they will notify parties that one of their options is to discontinue relations as a host community and a licensed applicant. So you're going to allow a host community to end relations with a marijuana establishment just because they don't want to comply with the new law, What about cannabis operators, especially social equity and economic empowerment cannabis operators who spent their entire life savings on this endeavor? But because the host community doesn't want to follow the law, now the operator is screwed. Failure to submit a compliant HCA may constitute grounds for denial. This is extremely damaging to marijuana establishments. If there's a failure to submit a compliant HCA, instead of denying a marijuana establishment, there should be a penalty to the host community until they do submit a compliant HCA. And then in regards to the equity section of the draft regulations, I believe that municipalities should be penalized if they didn't have their initial policies and procedures in place by July 1st, as required by the legislator in Chapter 180, Section 25. Also include a provision that says if host communities have a cap on HCAs, they don't have, and they have not yet reached their cap, so therefore they still have some available licenses, then 50% of those should go to an equity, social equity or economic empowerment. Currently, regs say only if a host community later decides to allow additional licenses, then the 50% of those should be equity. But I'm saying that if they still haven't reached their cap, then 50% should go to equity. And then my final point would be under the required practices when negotiating with an equity applicant, to put some language in there that says that the municipality will not drag out negotiations. Currently, I've spent $30,000 on attorney fees to negotiate an HCA that I still don't have. And as a social equity and a small business owner, it is draining my pockets. Thank you.
Thank you, and thank you for your thoughtful. You've sent us some very good information, and we appreciate it. Thank you so much. Devin Alexander, and then after Devin is Jeremiah McKinnon.
Good morning, Cannabis Control Commission. My name is Devin Alexander, and I'm the CEO, co-founder, and majority owner of Rolling Relief, a social equity certified marijuana delivery operator in the city of Newton, the city of Newton's first Black-owned business and equity business. I could stand up here for hours talking about all the things that we need to get changed today in this industry, in this state, but I'll keep it brief. My main concern is HCAs today and HCA reform. Last year, Governor Baker signed into law Chapter 180 in August of last year, and it took effect in November of last year. So you guys have a legal state mandate to have the regulations promulgated by November 9th of this year. However, you will not be enforcing this HCA reform until May 2024. That is a 6-month period in between, which leaves it open to more lawsuits, more corruption, more extortion. Now, there are certain associations that claim they are for equity, but that's just a lie. It's all talk. They are not. The marijuana delivery operator license was a license created 3 years ago, and these same organizations spoke out against us and filed a lawsuit against us. So when they claim to be for equity, you can't take that serious. Their actions prove they are not for equity. Now they are nervous over this new reform, and they say it has not been done properly. Come on now, you know that's just not true. You guys have done a great job, and I cannot wait until you guys have control of HCAs, but we cannot wait 6 months. That is just too long. That is literally a year in between when the law took effect, when you guys have promulgated it. It should be November 16th that you guys should have control of the HCAs. I also want to go on record by saying I do not believe sex offenders should be able to work in this industry. Let's move this forward. Let's keep on going. Let's get rid of this low-hanging fruit so we can get to the real important matters, such as the two-driver issue, which has been hamstringing delivery companies for quite some time now. All right. Thank you very much. Appreciate you all.
Thanks, Devin. Appreciate it. On Jeremiah McKinnon. Oh, there it is. And then after Jeremiah McKinnon is Frank Shaw.
Good morning, Commissioners. Thank you for allowing me to speak today. I want to keep it brief and allow others to speak, but I want to say I applaud this update. And, laws need change. This cannabis industry is new, and we need to learn from the mistakes, or, there's a learning curve. So I'm glad that the laws were changed and that these regs are being updated. And this illustrates a collective commitment to making an equitable industry, which I know is it's something that's ongoing. And whether we're talking about 2016 or 2023, rooting our rules in fairness and accessibility is important. And, as medical cannabis advocate, I saw firsthand the process of, host community agreements back in the medical days before legalization happened. So equity does go beyond businesses. This is about people. And from that perspective, representing patients, I wanted to come today to talk about how telehealth has bridged the gap and made access to medical cannabis care more equitable. And patients, it's important that we don't leave patients behind, and because of their disability, their location, or their financial means. The Board of Registration of Medicine in Massachusetts says that a face-to-face encounter between a physician and the patient is not required prior to healthcare delivery via telemedicine. The majority of healthcare providers in the medical program are physicians. So this is how the board that controls and regulates physicians sees medicine. Is the commission defining medicine differently? We have to be in alignment with the changes that have happened in state law since the pandemic started that have made telehealth as equal to in-person care. And by accommodating in virtual visits, we've invited more patients to participate in the medical program and benefit from access. So can we truly transform equity if we are not using this transformative tool? And I know the telehealth waivers are set to expire at the end of the year. Our group feels that this is the perfect time. It's a very simple edit. Please take a look at the final comment that we did send, because we provided draft language to make this edit. And while we move in the right direction with these adjustments, I hope we can do so with a holistic approach. Equity is not just about business dealings, but about patients who find it equitable to access their medicine. And lastly, I will just say that it's not lost on me, this meeting is hybrid. You are accommodating those who cannot make it here today at this time in physical form. Let me just turn it on its head. I've testified in person at public hearings before to the commission. What if you made it so that way I could testify virtually, but someone who's new here today, they had to come here at 10 in the morning? You're seeing how this, so I know there is the waivers coming at the end of the year. I just hope that we can make this permanent. Thank you.
Thank you. Frank Shaw, and then after Frank Shaw is Nicholas Obolensky. Need to get him a chair. Frank, if you need a chair, would you like a chair?
That would be more appreciated.
Thank you. Yeah, again, the table is there for folks who are not easily standable.
I understand. Thank you. Thank you very much. I have a visual problem too, so I got to go slow.
Again, so there's the timer, and again, and some people have been hearing the beeper and then jumping off. The first beep is yellow, the last beep is when I step in, so. Thank you.
Can you hear me?
Yes, we can. Thank you.
Does it work?
Yep.
Good.
If you want to pull it a little closer, you can pull it closer. There you go.
Thank you. Good morning. Thank you for holding this hearing and allowing me to speak today. My name is Frank Shaw, and since March 2021, I have served as a registered qualified patient advisor on the Massachusetts Cannabis Advisory Board. For many years, I have seen the cannabis industry involved, and from my perspective, this draft represents a big step in the right direction. In the early days, medical marijuana companies had to obtain letters of non-opposition from the municipalities before they can apply for a state license. While these letters evolved into today's host community agreements, it was not uncommon for cities and towns to be more interested in the money, often at the expense of developing an equitable industry. Now with this draft, the Commission will finally review the host community agreements in an effort to establish a more equitable licensing process. This is crucial, as there continues to be a lack of equity in the cannabis industry, which concerns me as a patient and a policy advisor. While some argue at the Commission's equity incentives have generally missed the mark, it widely acknowledged that it that this is especially true for the medical program. Equity in the cannabis includes medical too. It's undeniable that the telehealth has made the process of assessing medical cannabis care through equitable means. As patient advisor, I meet a lot of patients. I also speak to a lot of individuals who are interested in getting their medical card for the first time. For first-time patients, the option can be certifying virtually can be a game changer. I'm elderly and struggle with mobility issues, so I understand that getting to a physical location on a given day can be difficult for a number of people beyond myself. That is why I'm asking the Commission to update the regulations during this adjustment to eliminate the in-person visit requirement for new patients. Since March of 2020, the Commission has waived this requirement, and it is about time that this policy is enshrined into the regulation. This is a perfect time to include this simple yet significant change. The telehealth waivers are set to expire at the end of the year. Please don't forget about the importance of telehealth and the impact it has on making access to medical program equitable. Thank you for your time and indulgence.
Thank you very much, Frank, and perfect timing. Appreciate it. Next is Nicholas Obolensky, and then after Nick is Sean Cooney. If you can be up and ready after Nicholas speaks. Thank you.
Good morning. Thank you, Commissioners. My remarks are a little longer than 3 minutes, but I will do my best to tidy them
You can
up.
always submit written testimony.
I've submitted this as well. As I said, my name is Nicholas Obolensky. I'm a partner at Obolensky & Balcom in Providence, Rhode Island, and I've assisted numerous clients in Massachusetts with their cannabis industry municipal licensing needs, and I'm going to focus on host community agreements and the community impact fee components of the draft regulations. There's obviously a lot to say, but due to time constraints, I'm going to focus on the need for these draft regulations as they pertain to community impact fees and social equity program participants to be retroactive. And first, I would like to say that, I talk about the original legislation. The original Section 3D stated that a host community may include a community impact fee or that community, provided that the fee is reasonably related to the costs imposed upon the municipality by the operation of that establishment, and those costs need to be documented and considered a public record. So I think the law was clear on its face then. I think that the only thing that the legislature did was clarified the law as it stood. I never had a doubt what that meant, and I spent the last 5 years banging my head against the wall, negotiating with municipalities over what they've been instructed by their council, primarily KP Law, what that clause permits. What I'm saying is that that clause never permitted the overreach of municipalities to begin with. And when I hear that municipalities are negotiating in good faith, I laugh, because almost all of my clients have been over a barrel. I've been routinely pushed back on to provide waivers of the town's need to quantify or document its cost, waivers of the right to dispute the fees, waivers all over the place, essentially allowing municipalities to collect 3% of a business's gross revenue carte blanche. And I was rarely very successful and never succeeded in getting a municipality to agree on my understanding of the statute. Now, fast forward to 2022, the legislature finally heard the complaints, recognized the need to clarify the law, and did so. Now, I'll skip the highlights of the ways that it has refined the law. But my point is that although the amendment to Section 3D became effective in November of 2022, I'm still being confronted with municipalities pushing back on these amendments, asking operators to waive certain aspects of the revised law, and asking them to sign separate contracts like MOUs or MOAs to circumvent the clarified HCA requirements. Further, I have clients that signed HCAs prior to the law becoming effective, but that are not yet operational. But the municipalities are refusing to amend the HCAs signed prior to the law change to comport with current law. What makes this more egregious is that some of these same municipalities are seeking to take advantage of the benefits of the amended legislation, like accepting 4% in tax revenue from social equity businesses, or getting the 8 years period to collect the impact fees, but they're not giving those same benefits to the operators of the changed law. I find it disgusting. I find it bad faith. These recalcitrant towns have been avoiding finalizing HCAs since the passage of this amendment, thereby hamstringing operators that are hemorrhaging money as they wait for the municipal license, as they wait for their municipal license approval. Because they keep pointing to the draft regulations that are at issue today and say, well, let's wait for the draft regulations to come out. Let's see what the CCC does. I've been dealing with this since November of last year. Towns keep kicking down the road using the CCC as a shield for not fairly entering into these requirements. So I have clients in this position, and I think there's a real need for these regulations to specifically and clearly state that their provisions are retroactive. And I'd like them to be retroactive to 2018 because I think the law was clear then. But at the very least, they should be retroactive to when the law passed in August of 2022 or November of 2022. And no company that is not operational but signed an HCA prior to the change of the law should have to adhere to those old standards. The time that
I'm taking it from baseball to football. So
simply stated, HCAs ought to be in compliance with current applicable law at the time a business becomes operational.
thank you. And again, you have an opportunity to follow up individually with each of the commissioners. We apologize because you're very
No, it's okay. I
don't know
want.
if anyone has any questions. I mean, again,
I have one.
go ahead.
Can you just repeat that last? You said HCAs need to be applicable. Do you mind just-
HCAs ought to be in compliance with the current applicable laws and regulations at the time that the business becomes operational. Because you've got people that signed HCAs 3 years ago before the law changed, but they've been spinning their wheels trying to get open. Now everything's changed, it's been clarified, but they can't take advantage because the towns say, well, you signed it back then, so it relates back. So they keep using various legal gymnastics to prevent them from taking advantage of the new law. But my point is that they're going to take the 4% tax. They're going to take the 8-year pay period, but they're not going to let the operators do it. So it's patently unfair. And that's, and I think you have the legal ability to make it retroactive at the very least to 2022 to November at the very least, August probably.
Thank you. And again, sorry, again, apologizing in advance to everybody who we're trying to get through all of this, but feel free to reach out. I'm going to drive everyone here crazy, but reach out to us individually if you feel, obviously you can put anything in writing. And if you want to have post some additional questions and comments, but we have to do it quickly. So anyway, next up is Sean Cooney, and then after Sean Cooney is Brenda Quintana. Sean, are you here? Sean Cooney? And I don't see Sean Cooney. And again, if there are people who are on the list to be in person, but are actually listening online, I'm trying to think of who they might connect. You know what I mean? There might be some mix-up or some last-minute decision. So I don't know how they would manage it because we've already closed it. Mercedes, do you have an issue?
I'll touch base with Zoom to see if there's any.
Say it again?
I'll touch base with Zoom to see if we've had any correspondence on that item.
Yeah, could you just see?
Yeah, I was the opposite, actually. I was supposed to be remote.
You were supposed to be online, but you've rectified that with the staff?
Actually, this is good time. I'll just bring you that update.
Okay, great. Again, sorry for the technical. We're still, hybrid is good, but not always easy. So anyway, so I'm going to assume that Sean Cooney is not here. I don't know what you want me to tell Sean Cooney if he's listening remotely.
You can send an email to the inbox and you can send him the Zoom link.
So to the commission at cccmass.com.
Yes.
Okay. All right. Brenda Quintana. And then after that is Ryan Dominguez. Hey, Brenda.
Good morning. I hope it's okay if I brought my laptop. I don't have a printer. All right. Well, thank you so much for this time. Good morning, Chair O'Brien and the commissioners and other staff and leaders here on behalf of the Cannabis Control Commission. My name is Brenda Quintana, and I am here to represent the Massachusetts Coalition for Occupational Safety and Health, MASCOSH. It's a nonprofit that supports educational advocacy dedicated to improving the health and safety of workers in the state. At MASCOSH, we are committed to the fundamental belief that all workers should have the right to earn their living and return home alive and well. For close to 50 years, MASCOSH has been working closely with many unions, occupational safety experts, community groups, and workers themselves to advocate and win policies for safer and healthier working conditions in Massachusetts. I'd like to begin our testimony by recalling the untimely and tragic death of Lorna McMurray, a Massachusetts cannabis worker who was only 27 years old. Lorna's death from asthma triggered by workplace exposure to cannabis serves as a stark reminder of the pressing need to improve worker safety in the cannabis industry. We want to ensure that such heartbreaking tragedies never happen again. While OSHA fined her employer $14,000 for failing to provide training about chemical hazard, this alone would not have saved Lorna's life. OSHA currently lacks regulations to protect against the hazard that took Lorna's life. Therefore, it is incumbent upon our state, particularly under the enforcement power of the CCC, to develop and operationalize enforceable rules specifically tailored to the health and safety needs of workers in this industry. To achieve this, Massachusetts needs to take a comprehensive approach to assure the consideration of worker health and safety is integral throughout the cannabis industry. This includes enforceable requirements for marijuana establishments to comply with workplace health and safety standards, integration of workplace health and safety in required worker training programs, and the provision of technical assistance on workplace health and safety to employers and host communities. We commend the CCC for its goal of promoting equity and developing new regulations that will encourage communities that will have been historically harmed to have better access to this industry. That said, it is well documented that immigrants and workers of color are overrepresented in jobs of a higher risk of occupational illness and injury and death in general. As workers of color are already at high risk of illness and injury, the CCC must ensure the unsafe conditions are not perpetuated in this industry. To promote equity, it is critical that the CCC develop concrete measures to protect the health and safety and lives of all who work in this industry. In order to do this, we propose several key areas where health and safety measures can be implemented. The CCC should require a workplace injury and illness prevention program tailored to the cannabis industry. For training, incorporate health and safety and responsible vendor basic core training that includes hazard recognition and controls, emergency response, and worker rights, including the right to report issues without fear of retaliation and proper recording of injuries and illnesses. I'm almost done, I'm so sorry. And we also suggest that they offer technical assistance to small businesses for the effective implementation of health and safety measures, and for host community agreements, it would be great to develop standardized occupational health and safety language to be incorporated into the model host agreement. And so all of that is to say that I do believe, the CCC holds the licensing power to support and uplift worker health and safety. And at MASCOSH, we extend our offered to assist in this endeavor and figure out solutions.
I first of all just want to say thank you. You and I have had a conversation. You know that this has been front and center for a number of us. We're coming up on the 2-year mark.
Absolutely.
Of Lorna dying. We did not know about that as commissioners for quite some time, which was troubling to many of us. And we know that we have a little bit more work that we need to do. One, in terms of creating an anonymous whistleblower system. We're still working on getting some of that done, but also some of the points that you've raised. We've seen some of this in some of the conditions that licensees are proactively filing about training and what they are doing to make sure that they're protecting health and safety. But it's my belief that we have to take a look at what our core training is and make sure that we're doing more on public safety, especially for people working in potentially hazardous situations who don't need to check a license, but they're trained to check a license in this basic service. So that's something that we need to do. It's something I'm very passionate about, and I thank you for bringing that to the forefront.
I just wanted to ask first,
of course,
thank you so much. I want to make sure we can get in contact with you.
Absolutely.
So if you don't mind, even when you sit down, you just send an email. would
Yeah.
share your information, that would be awesome.
I'm happy to leave my email. What would be the best way to do that?
Yeah, just tell us.
My email is brenda.q@masskosh.org. Masskosh is MASSCOSH. And I extend that invitation to the rest of the community here as well. I look forward to find different ways to bring in workers, other interested community members to find a solution to this issue.
I just want to thank you as well. We were all hit very hard by Lorna's untimely passing. We never want to see a Lorna happen again. And we need to learn more. You had mentioned asthma. We need to learn more about that in cannabis dust and how they are related. And as the chair alluded to, commissioners shouldn't learn about it reading it in the newspaper 9 months after the fact. It's unfortunate, and we never want to see this happen again. So I want to thank you and your organization, and we have much work to do around this issue. So thank you very much.
Thank you.
Thank you all for your time.
Appreciate it. And then Ryan Dominguez, and then after Ryan is Caroline Pino. Hey.
Madam Chair and Commissioners of the Cannabis Control Commission, my name is Ryan Dominguez, and I'm the Executive Director for Mass Cultivate Ed and a current CAB member. Today, however, I'm speaking on behalf of the Massachusetts Cannabis Coalition, which I started this year to help bring together our cannabis, ancillary, and nonprofit partners to push for better policies and pool our resources to collectively write comments, work on social impact, business development, and research that will benefit every cannabis business and community. On behalf of our organizations, I would like to say thank you for your leadership and your work for putting HCA's municipal equity and suitability front and center with today's hearing. I was able to provide written comments previously on municipal equity and suitability, so today I will be focusing my time on the HCA reform, which affects all businesses. We applaud the work that has been done to implement Chapter 180 and protect our cannabis industry in Massachusetts. The regulation changes have done a great deal to promote fairness and give businesses a chance to survive in this tough economic climate. With that, there are three main opportunities for us to strengthen the draft regulations and close any potential loopholes which can and will be abused. First, I would like to stress the need and urgency for an expedited implementation timeline for the HCA review process, starting earlier than March 2024 and with a review period that is shorter than 3 months. Second, I would like to urge the Commission to ensure that the HCA review and certification process does not hinder license renewals by exposing them to potential loss of license due to a municipality's unwillingness to enter into a compliant HCA. Third, I would like to underline the importance of stronger remedies for non-compliant HCAs. Remedies such as the equitable relief provided for a location change do not provide a substantial recourse for many businesses and will lead to business closures and unemployment for those currently trying to find their way in the industry. Today, some municipalities have continued to enforce HCAs that would not be compliant with the current regulations. With each month that passes without a review or determination by the CCC is another month of exorbitant fees being charged to our most vulnerable businesses. As you know, pricing pressures and competition have created even smaller margins for our businesses to succeed. And the only recourse that companies have to recoup any non-compliant fees would be through litigation. And in the economic reality that our businesses face, and coupled with wanting to make things work in their host community, that is just not an option. The CCC has an opportunity to send a clear signal to both host communities and businesses. We urge you to do this by moving up the implementation timeline and prioritizing a model HCA soon after the regulations are promulgated. We also ask that you put in stronger protections and remedies for all of our businesses. And with that, I thank you for your leadership on HCA reform, and I thank you for your time here and for reviewing our written comments, and I look forward to talking about this more with you.
Thank you. Look forward to speaking to you in the future. Thanks very much, Ryan. We appreciate your time. Caroline Pino, and then after Caroline is Fran McGuire.
Thank you, Commissioners. I'm Caroline Pino. I'm an Economic Empowerment Designee in Haverhill, and I have a few thoughts today regarding HCAs. STEM is currently in litigation with the City of Haverhill regarding our host community agreement and the community impact fee. And on the advice of counsel, I will refrain from any specific comment about that court case. First, Operators will need clarity on when any new HCA changes will take effect and what happens in the transition period. For example, if there is an HCA renewal due between the date the regulations are published and the expected date of enactment in 2024, what guidance should both municipalities and operators be acting under? Should there be a temporary HCA in place until the regulations kick in as per the draft regulations? Second, it is important that the new regulations include language regarding what happens if a municipality chooses not to renew an HCA. Moving or closing a business is a huge expense, and while the CCC may not have the ability to force a municipality to renew an HCA, there may be an underlying legal issue associated with a potential arbitrary and capricious non-renewal on account of the volunteer political whim of the current board of the municipality at the time of renewal. The regulation should address this, and this is an undue burden on the operator if the municipality just decides not to renew. There is no penalty or regulatory punishment for a municipality who has the power, though through this is to just close the business down. There needs to be a provision in the regulations that lays out an acceptable notice period, monetary impacts and penalties, an acceptable timeframe for closing or relocation. Third, there should be clarity and consistency regarding municipal accounting. The CCC must have the process in place and examination authority, penalties, and corrective actions to municipalities to determine real versus fake costs. We have seen examples of municipalities creating dubious expenses and attributing them without any evidence or accountability to legal cannabis. The CCC must be aware of this and must take steps to prevent municipalities from using deceptive spending justifications, including in the area of budget appropriations. I applaud the CCC for considering new HCA regulations, and I'll point out that, as always, the devil is in the details. Thank you.
Thank you very much, Caroline. Next is Fran McGuire, and after that, Cleon Byron. Thank you.
Good morning. Thank you. I'm Fran McGuire from Stafford Green. We're an outdoor cultivator, a Tier 5 in Cheshire, Mass. Most people may not know that it's a tiny Berkshire, northern Berkshire town between Pittsfield and North Adams. Route 8 runs right through it. I appreciate that. I'm looking at Section 10 and then Clause D1, where a marijuana establishment shall negotiate for an HCA, but it doesn't say that the host community shall negotiate an HCA. And then I appreciate Section 14, Clause 31, because it does make the towns establish stuff for like we're a certified minority business entity. But what alarmed me is I have a newsletter from a cannabis law firm, and they're talking about options if either party can't agree on an HCA or doesn't even negotiate. And the option that really alarmed me, it says continued relations as a host community and a licensed applicant marijuana establishment. And then in boldface, he goes on to write, a host community's option to unilaterally discontinue relations should be a major concern for all marijuana establishments. Even a marijuana establishment that is fully operational and is only in its first or second year of a 5-year HCA would be at risk of being shut down by the host community if it is unhappy with the limitations that the CCC imposes on their HCA. Our host community agreement was negotiated 5 years, or not 5 years ago, but when the town board of selectmen was 3 members, and there's nothing burdensome about this HCA except that we have to pay them $5,000 a year, which we have for 4 years. But moving forward, the board has been expanded to 5 members, 3 of which have demonstrated adversity to cannabis per se. And if they come back to us and don't just ignore us or don't even negotiate, what's our leverage? I mean, I'm looking at, Clause 31 and Section 13 because we are a minority business entity. But What are we relegated to? Lawsuits? I mean, can't the CCC in section 10 D1 say that the establishment shall negotiate and the host community shall negotiate? Isn't there some kind of leverage to put on them so that they will come to the table? I mean, I think the way it's written, there's a door open for marijuana, cannabis prejudice to enter into municipal governance. And not just because of money, and I know we're talking about a lot of money this morning, but just because of prejudice, cause the product can obfuscate and, you know, the whole process. And it, I mean, I'm just looking at a doorway where cannabis prejudice enters into the Massachusetts regulated cannabis industry. Thank you.
Thank you very much. I appreciate it. Thanks, Fran. Then Cleon Byron, and after that, Ilya Ross.
Hello everyone, Madam Chair, Commissioners, great to meet you guys. I'm a small business owner, second generation, and doing this host community agreement and time and money is very hard. And I just want to be an advocate for social equity and people who come from a small business who have to take it out of their pocket and understand, you know, time is money and profit and loss is huge when it comes to business. And with the host community agreement, the changes you made are awesome. You did a good job because for small business owners like us and social equity owners, we need this process to go a little bit quicker. Because the time, there's so many things that can happen in between. We do have real lives in between this also, businesses, children, and things like that. So I just wanted to say that I do have a written statement that I will send you guys later. And thank you for my time.
Thank you for coming. Appreciate it. Thank you, Cleon. Next is Ilya Ross, and then after that is Thomas Dolan.
Madam Chair, if I may, please, just speak closer to the mic. We're getting some feedback from Zoom that folks can't hear. So
Testing. Is that good? Hi, good morning, Chair O'Brien, commissioners, staff. Thank you very much for hosting this opportunity for industry stakeholders to voice their input on these very important proposed changes. My name is Ilya Ross. I am the Vice President of Legal and Corporate Development at LDE Holdings, DBA Trade Routes. Trade Routes is a Tier 2 cultivator, product manufacturer, and retailer. As importantly to us, and as a matter of pride, we were the first social equity operator licensed across all three verticals. Our principal and a number of our employees have indeed been incarcerated victims of the drug war. And in our few years of operation, we have come to the belief of the immense value, of course, that we're biased in this respect, that legacy operators bring to this industry. And of course, the ability to make this a diverse and inclusive industry, which I know is still a work in process. I think those two factors combined make everyone in this room vested stakeholders in the success of this social equity program. And to that end, we do want to voice support for the commission, particularly in setting, parameters and protocols for ensuring social equity at the municipal level. We've heard comments today that, perhaps more detail may be warranted, more templates. All of these things are true, but we understand these things take time, and, minimum parameters are a great first step. We also support the changes addressing contractual and negotiation requirements pertaining to host community agreements, including certification of community impact fees, the requirement that such fees be reasonably related to actual costs incurred, and a delineation of local fees imposed on non-marijuana businesses as part of the CIF review process. We believe these changes support precisely the type of transparency, accountability, and state-level regulatory protection that can continue to support local communities through the growth of cannabis revenues, while at the same time protecting operators from unduly burdensome and opaque local obligations. I would like to point out one regulatory provision, this is in written remarks, respecting the HCA waiver and any rescission of such waiver contained in 935 CMR 500.180 5I. Specifically, the second sentence of this provision states, an HCA waiver may only be rescinded on commission approval of an HCA subsequently executed and submitted by the parties. To avoid a potential scenario where maybe a municipality agrees to a waiver under the perhaps non-contractual sign agreement that it will be rescinded with a subsequent HCA for a set fee, this contradicts other provisions of the regs, which I don't have time to get into, but is a very helpful enforcement mechanism. There's no, but to enforce it, and this last thing I'll say, I just advise staff in reviewing any prospective waiver rescission to specifically ask questions as to whether any such arrangement was ever contemplated in that process. Thank you for your time.
Questions on that? Any questions? Okay. Next is Thomas Dolan, and then Karen Konarski.
Good morning.
Hi.
Thanks for having me, and I appreciate you allowing me to be here in person, as I do believe it is extraordinarily important to have face-to-face conversations, which is where I am premising my comments and around social consumption in the hospitality business. I am a 35-year veteran of the hospitality business with 10 years in operations and 25 years in asset management and advisory. Also an adjunct professor at an institution here in Massachusetts, and in the process of developing a cannabis lifestyle hotel and hospitality concept and brand. I'm going to first premise social consumption versus public consumption. I believe the terms got conflated in a couple of the listening sessions in the past, and talking purely about the fun aspect of this process, which is consuming it with friends, with family, with each other. And social consumption is not new. It's been around. It's legal today. It's just not legal in a private or public venue. Or I should say, it is in a private venue, it is available in your home. In other words, you can have people over to socially consume and enjoy this and have fun. You can have as much alcohol as you want as well, I must add. So this isn't a new concept. The hospitality industry is about personal interaction. It's about social touch. It's about being able to touch you and communicate with you. And it's about the delivery of experiences. That's the difference between the retail industry and social consumption. That's the difference between a package store and a restaurant. It's about that experience. And that's what we want to be able to profess here. And that's the only thing I'm talking about. So when we start talking about social consumption, there are aspects of it that, like smoking, that are intrusive to guests, and there are other aspects that are not, like beverages. So much like the alcohol business, you bifurcate these licenses. Excuse me. Smoking is different than consumption. Beverages are becoming more common. Tinctures, edibles, and these things. I think it's personally irresponsible to not allow food in social consumption. I think it's much like alcohol, right? It does help that. I understand the reason for it is you don't want people putting it in the food, right? And they can put it in the food today in any restaurant they want, right? So what difference does it make whether you allow it, food or not, in a venue? And the imagery of the language right now makes it feel like you're going to visit a friend in prison or a family member in prison. You got to go through this other door. You got to buy it here, go through this other door, be strip searched for all intents and purposes, and in order to go consume it in this sterile room is basically what I'm setting up. I'm talking about comedy clubs. I'm talking about food. I'm talking about music and sports and any kind of table or games. That's what we're talking about. And right now, all of these things need to be fleshed out a little bit in the regulations, especially this bifurcation of licenses related from beverages to smoking. And I know my time's getting short here. Lastly, I would say, based on social consumption, based on the current regulations, there's nothing that I've been able to find that taxes social consumption. Yes, selling to a consumer is considered retail according to CMR, I think 64N 1.1, something to that effect. And that is retail, but it doesn't specifically say that social consumption is retail. In other words, remember, you're limiting the amount that you can sell to 20 milligrams. That's a pretty good amount. But you don't limit alcohol, or the state or Commonwealth does not limit alcohol, why are they limiting this? Self-regulation is huge. The regulation, the trust of your bartenders, your bud tenders, and whoever else is delivering the product is what you really need. And that's it. We're self-regulated in the hospitality industry. And I will cut off and leave it to that.
We're going to get there eventually.
Yes.
You're going to have another bite at the apple, no pun intended, the table here, to be able to talk to us again on social.
And I will put it in, and I will say there's nothing that prevents anybody from bringing cannabis into a restaurant today and consuming it. Right? In fact, it specifically says that in the ABCC. You can bring it in, you can bring a can. The smoking aspect is different, and I will differentiate. Thank you very much.
Thank you. And again, this is going to be an ongoing dialogue when we start to focus on that
And
issue.
that would be the only thing, is that I would strongly encourage that you consult with hospitality professionals, people in the food and beverage business, people from academia, and people from this industry that spent a long time doing it.
We will do that.
Yeah,
Thank you again. Sorry for the.
No worries.
I'm sorry, can you remind us your name?
Thomas Dolan.
Thomas, all right. You're
Thank
right.
you.
Okay, thank you, Thomas.
Okay, thank you, Thomas. Next, we have Kernan Konarski. I'm saying that right? Kernan, are you here? Hope you didn't bail. You left? You left? Okay, thank you. And then Son Adede, I'm really usually good at names. Adede, am I saying it right?
Hi, how you doing, Miss O'Brien?
Pronounce it for me so I say it right. I'm embarrassed.
No, you did pretty good. You did pretty good. I just became a U.S. citizen, so you can call me Sean now. It's a lot more simple. So let's go with Sean. So hi, Miss Chair, Miss O'Brien. My name is Sean Adedeji. I'm here. We're a small business. Sean, he's amazing, by the way. He just spoke not too long ago. The handsome guy over there in Athol. We own a small business in Athol, Mass, and we own a small business in Orange and in Williamstown. There's a lot. You guys have been doing a really great job. As our preferred partners, we want to say thank you for supporting small businesses like ours. I know that I had a personal life incident that happened because I did go through a divorce, which it was a personal thing, and it was hard for me to separate my personal life from my business life, and I kind of got in trouble. I owned up to it. I give God all the glory. I'm back at work. You see, I got my tie on. I see you looking really serious. Hi, sir. Hopefully you're having a great day. So hey, look. So what we're looking to do, and what we're looking to ask the commission. I know you guys have a lot of work on your table right now. Is seeing what is the step-by-step process. Like, we understand that we're currently suspended. We understand what we that process, and we've been emailing the commission for about a day plus now. I know you guys are extremely busy. You have new talents coming to the table. You have existing operators that are currently working their butts off, and we appreciate that. I'm just a small business. I'm one man. I'm a dad of a 5-year-old. I actually go to gymnastic class, ballet outside of work. My dancing is impeccable after hanging out with my daughter and her team. It's actually pretty good now. What we're pushing for outside of being a dad, outside of work, is just basically get our store back open. It's simple. We understand the commission is busy. I'm going to leave it at that. I know there's a lot of people that want to speak. I just want to say thank you for giving me a minute plus of your time just to say you guys are doing a good job. We're looking to get back open. We have some deadlines that we have to meet from some preferred partners. And that's one of the reasons why we're wondering what is the expedited process, just so we can meet our personal deadline, because we are a business. No matter what, our investors looked at me and it was like, hey man, how much money you have? They didn't even say, hey, are you okay? You want a hug? None of that, right? All they cared about was the money. So as a small business owner, we're just looking to get open. Thank you so much for giving me a minute of your time. Y'all look beautiful. Great. Thank you so much. God bless you. Have a good one.
Thank you so much. Thank you. And we have one last in-person to testify. David O'Brien, I don't think that we have anybody else that I have signed up on the list. Now, I will tell you, David will testify. It's our plan to take our lunch break now. That's what I have been asked. And so we're going to make it very, very short. And then we will come back a little after noon for the continuation of the remote. So again, David O'Brien, no relation, is the last speaker here. David, if you'd like to come on up here.
Thank you, Madam Chair. Good morning. Being the last thing between lunch and the rest of everyone's
It's
day.
only 11:30, it's kind of brunch.
Yeah, okay. Thank you first to Commissioner Roy and Commissioner Concepcion for leading the working group on HCA's. Thank you, Chairwoman O'Brien and Commissioner Roy, for attending an HCA regional roundtable we had last month in Uxbridge to hear firsthand from operators and their daily challenges when it comes to HCA's and what they'd like to see changed. I want to also thank some of our Mass CBA members who came today to testify. And I just want to thank all commissioners for coming to our regional roundtables regularly to hear firsthand for the challenges that operators are facing in Massachusetts. Chairwoman O'Brien, you often ask over the last several months, what are the types of things policy-wise that we can do as a commission to help make businesses of all shapes and sizes more sustainable, more profitable in this ever increasing difficulty of running a cannabis business. Implement the regs for HCA's is the first and foremost thing you can do. As has been said earlier, Governor Baker signed the regs better than a year ago. 90 days from that August date was when the parts of that legislation went into effect. I would ask you to consider, and I'll make some recommendations later, implementing some of the elements of the regulations sooner. Don't wait. A little history is in order. I know folks, the 5 commissioners here, I don't think are around, but you probably paid attention to it. In 2017, the legislature in the conference committee looked at adding host community agreements or community impact fees. The language was cut and pasted from the gaming law, little known fact. And it was intended to cover extra costs that municipalities may incur as a result of hosting a cannabis license. No more, no less than that. Up to 3% of what the proceeds were of a cannabis business. It is run amok. Municipalities have run with that 3%. They've not proven how they've spent that money. Operators have asked for years for receipts and they've not gotten them, which led up to why we have the change in the law. It's a reason why so many people throughout the last several years, including the original Joint Marijuana Policy Committee chairs, Chairman Cusack in the House and Chairwoman Jalen in the Senate, said that municipalities were out of bounds when it came to over-collecting what I have called legalized extortion to operate in a community. Several of your predecessors, the original 5 commissioners, were very public about saying that municipalities were overreaching with over-collection. You have issued guidance, I think, on 2 occasions as a commission. I think the last time in November of 21, saying that these are the reasonably related categories. I don't think it even filled a page. We've done 2 separate analyses as Mass Cannabis Business Association, the most recent one last spring. Municipalities are taking this and putting it in the general fund and not providing any evidence of how they spend it. So I'd ask you to consider a few recommendations. First, and it's been spoken earlier, make the effective date of the new regulations the first full year of when the law went into effect. So that would be January 1st of 2023. Think of it as similar to what we did with the 280E decoupling applying to January 1st of 2022. The legislature envisioned that the tax benefit could accrue to operating businesses in that year. Do the same thing. You taking a year to get this done with respect shouldn't cost us as operators. If you did an example of a $5 million store, 3% of $5 million is $150,000 a year. That's $12,500 a month. So in the category of 300 plus retailers, many of which are standalone operations, they're paying $12,500 for every month until this policy is enacted. It's a lot of money. So I ask you to consider that as the operative date. I would invite all operators to submit through Mass CIP their HCA's. You have a format. You have an ability to collect this. This is not rocket science. I'm not asking you to look at them all, but everybody, the second you send that out, you would have a stampede of people submitting that electronically. And then I'd ask each of you to take 5 licenses each, randomly select them across the state. Each of you take 5 of them and work with your staff to follow through to see what redlining or marking up existing HCA's for compliance would look like. I'd ask you to issue the model HCA soon, and we remain a resource to you. Thank you.
Thank you very much. And again, sorry to everybody for cutting off testimony. We're just trying to make sure everybody gets a chance to speak. And again, everybody has an opportunity to send written testimony. So we will take a break. It's going to be a very short one. It's 20 minutes of 12 right now. We will start with the online testimony at 12:05. And again, I'll just ask Mercedes, have we shut the door now on people signing up for the remote testimony? Yes, Megan, okay. I got 3 yeses back there. Okay, so at 12:05, we will be back here, and then we will be taking the remote testimony, just giving the staff a chance to kind of fix things. Thanks, everybody. I entertain a motion to adjourn to 12:05. Commissioner Concepcion. Commissioner Roy. Commissioner Stebbins, chair votes aye. Go, everything? Yep, Gloria, good, Megan, good, everybody right now. Paul, running around. Good, all right, reconvening right now with our remote speakers. And the first up will be Linda Tyre, the mayor of Pittsfield, and then next up will be Mayor Paul Brodeur. So Mayor Tyre, there you are, looking mayoral, thank you.
Good afternoon, Madam Chair and Commissioners. Thank you for this opportunity to address you. I'm Linda Tyre, Mayor of the City of Pittsfield, and I'm the President of the Massachusetts Mayors Association. Pittsfield has been extraordinarily open and cooperative as the new cannabis industry begins making its mark on our economy. We passed a fair and protective local ordinance that allowed for 30 cannabis establishments. We developed a local process that is applied to all applicants regardless of type, location, or applicant background and experience. Pittsfield set up a system for the host community agreements that is also applied equally to all applicants, including how we calculate the community impact fee. Pittsfield has 7 recreational retail businesses in operation, 6 cultivation uses in operation, and 1 product manufacturer also in operation. 1 social equity applicant who just applied this week, 2 cultivation uses that have received zoning approvals and are moving through the building permit process, and 16 individual license applications that are winding through the CCC process. As we gained more experience with the cannabis industry, Pittsfield accepted the movement toward eliminating community impact fees. We offered amendments to all our current host community agreements that eliminated the payment of these impact fees. All establishments accepted and signed those amendments. Despite our welcoming approach and our commitment to fairness, we are now being sued by 2 cannabis establishments. This feels like a kick in the teeth. I am very concerned that interference with contracts that included the community impact fee, contracts that were signed by both sides in good faith, will sour support for any future cannabis establishments. Please consider a 2-tiered approach, allowing the current HCAs to expire. Then new regulations should be placed on future HCAs after the law has passed. Pittsfield's methods is proof that we value the intent of the law and the growth of a new industry. This leads me to my other comments on the draft regulations. Municipalities have no rights to appeal to the CCC if they are aggrieved by a cannabis establishment. Cities and towns are being burdened with more administrative tasks, requiring countless more hours of staff time. The CCC can issue sanctions against a host community if it is found to be incompliant and to publish a shame list. However, I do not see similar sanctions for the cannabis establishments if they are not compliant. This practice seems wholly unfair. The more I consider the added complexities proposed for the HCAs, the more I begin to wonder if the CCC should just eliminate host community agreements. Licensing and approvals could simply follow a state and local permitting process. Municipalities and cannabis establishments appear to be in agreement on one thing. The HCAs are not working for either party. This begs the question, should they be eliminated? And what is the public benefit of a host community agreement? I support the publication of the steps required for applicant process and host community agreements. We're doing that now. However, I am reluctant to support a scoring process that creates a system that may not be flexible and may actually temper our ability to issue social equity licenses. A requirement that we publish reports on all applications and applicants is redundant. This information can be provided through the public records process. I recommend the regulations simply refer to the state's public records law as it relates to the access of information. Thank you again for this opportunity to provide feedback on the proposed regulations. Pittsfield is committed to an ongoing partnership with the CCC and with our local cannabis establishments. Thank you.
Thank you, Mayor Tyre, appreciate that. And moving on to Paul Brodeur. And following Paul will be Brianna Longo-Cohn.
Thank you, Madam Chair. It is good to see you again, and thank you to the members of the commission for the opportunity to have this process and to reflect what an earlier speaker said. Having it in hybrid form is tremendously helpful to make sure you get everyone's perspective of the many stakeholders that are interested in this process. I will admit, as I listened to some of the comments this morning, I almost wanted to play some Darth Vader entry music based on what I was hearing from the perception of some cities and towns. And I must admit, as an outgoing mayor, I find that a little bit disappointing and honestly a little bit divorced from reality. Some of the proposed changes, particularly HCAs, do have dramatic negative effects on municipalities across the Commonwealth who negotiated host community agreements in good faith. Most cities and towns that entered into these agreements thought a deal was a deal, and certain parts of the draft regulation suggest this will not be the case. I have a little bit of a unique perspective, as I was a member of the House of Representatives when recreational cannabis became legal in the Commonwealth, but to be clear, not when the Chapter 180 revisions passed. I do recall our debate and discussion around implementing legalization having a huge focus on the financial benefits and costs to cities and towns as part of the paradigm of hosting retail establishments. It was certainly not the only focus of the legislature, but it was a crucial point of advocacy when we were figuring out the best way to get this industry off the ground. I also know that I was not mayor when Melrose negotiated its HCA, but I'm very familiar with how the process played out in my community, and I suspect the Melrose experience mirrors that of other communities, particularly early on. That experience was this: businesses wishing to enter the market in Melrose literally lined up outside the city hall, and I suspect town halls across the Commonwealth, to get access to the marketplace within our communities. To say they were eager to enter into these agreements vastly understates the case, quite frankly. And they were well represented by lawyers and lobbyists to protect their interests and to advocate on their behalf. Why those particular entities should get relief from existing contracts at this point is simply not fair. I don't want, however, to detract from the equity provisions that we all, I think, are trying to get to, and it is vitally important to adjust the rules going forward to eliminate some of the advantages that were enjoyed by folks with access to capital and lawyers and lobbyists as this process kicked off. I applaud those efforts, but I do not believe they need to be at the expense of cities and towns that have negotiated existing HCAs in good faith. As Sean from Athol mentioned, and as Ellie DiMatteo did so eloquently, I have to say that she's a Melrose resident. Part of what we do as municipalities is long-term planning and budgeting. I would analogize it to the challenge of a 9C Cup, where it's a little bit inside baseball, but Madam Chair, I know you know what I'm talking about, where you structure a financial plan with expectations on the 9C case, local aid or other assistance, and then it is pulled out from underneath you, and particularly in the world of capital planning and long-term financial issues. Cities and towns, again, in good faith, entered into these agreements with very sophisticated players for the most part, and now they're suggesting that we should change the nature of that structure. I quite frankly think that is not fair, and I do think it runs afoul of the Constitution. And in reflecting a little bit on the balance of power, I think we should be clear about there are different players with different access to relief. Our cannabis retailer has told us they're not paying anymore. That is part and parcel of negotiation and understood. But one of our earlier testifiers mentioned how cannabis growers or market participants can't possibly afford to stand up to the to the power of municipalities. Well, this municipality is negotiating with a very well-established, well-capitalized entity that entered the marketplace with eyes wide open. And they're represented by Burns and Levinson, not scraping together to hopefully get a mom and pop advocate to speak on their behalf. So I do want to applaud the work of the legislature and the advocates to open up the marketplace and to give fair access to folks that quite frankly have been shut out of the process and open up. I don't think, again, that should come at the expense of cities and towns in terms of existing HCAs. We know, as Linda Tyre made a great point about, HCAs perhaps can and should go away in the future, but those that were negotiated in good faith should stick around. Again, I thank you for your attention. I commend to your attention some of the testimony from my fellow municipal officials and certainly the great work that's done by the MMA to suggest a fair and reasonable compromise, which is the two-tiered process described so well in their work. So thank you very much. I appreciate the time and attention once again.
Thank you, Mr. Mayor, my friend. It's nice to see you. We appreciate that. Next up is the Mayor of Medford, Brianna Longo-Cohen. And for all speakers online, we've had our baseball analogy, which then went to a football analogy. You cannot see me politely doing the timeout signal. And so I'm hoping that you can keep an eye on that timer, especially with elected and appointed government officials. We're trying to give you as much leeway as possible beyond the 3 minutes, but I ask all speakers to just pay attention. We will let you get your point out, but if you could help me make sure that it runs smoothly. We have a lot of people waiting. Thank you. Thanks again, Madam Mayor, for joining us today. We appreciate it.
Thank you, Madam Chair, and members of the Cannabis Control Commission for allowing me to share some details about Medford and our marijuana licensing with you. We share the goals and the intent of the new law to provide greater equity within the industry while helping it to continue to grow. Medford has been a partner in this process and to this goal. Medford has 4 HCAs, and because of that, we have a tremendous amount to lose as it relates to the good faith negotiations that took place to get to that number. Our community drafted an ordinance and agreed to these host licenses with this funding and these benefits in mind. We are concerned that interfering with these existing contracts will result in extensive litigation and sour our community on allowing additional licenses in, defeating the important purpose of the new law. It will also ruin relationships between municipalities and cannabis businesses, which has been positive up until now. I personally spent countless hours, which took over 9 months, reviewing applications and negotiating these licenses. Equity was the first goal on my list of priorities. It's why I chose to negotiate with a social equity candidate out of order and reached an agreement with him in good faith. I took into account that they didn't have capital that others' company had. And I know that because other companies, some of the 9 that wanted licenses offered far more than I was even asking for to try to get a license. But I decided that one of my 3 retail licenses would go to the only social equity candidate in the pool. I want to state that there was absolutely no bullying whatsoever. Quite the opposite, actually, especially here in Medford. Putting additional requirements on us would likely mean we would spend many more hours, months, and a tremendous amount of legal fees on this, and it will have a detrimental effect on our community. As Mayor Broder mentioned, I negotiated in good faith for HCAs, and we have budgeted for the benefits that will come into Medford, and we desperately want to do good in those areas where these locations, these HCA licenses have been negotiated, and this will completely change that. I beg you, please consider a 2-tiered approach. Please allow our existing HCAs to expire. Please only apply these new regulations to HCAs made after the law was passed. Thank you for supporting cities and towns and for allowing me to speak today.
And thank you, Madam Mayor, for being so inside the time. We appreciate it very much, and your point's well taken. And again, we applaud what you've done, because we know that this isn't always easy, sort of in this kind of Wild West time, to be able to promote equity the way you have. So we all appreciate what you've done in the city of Medford. So thank you very much. Thank you. And next up is Janelle O'Neill from the town of Brookline. Janelle?
I'm getting a note that he is not present. You can go to the next one.
Okay, thank you. All right, moving on. It's Douglas Lapp, who is the town administrator of the town of my neighboring community, Rockland. Douglas Lapp.
Hello, thank you all very much for allowing me to participate today. As you just indicated, I'm Doug Lapp. I'm the town administrator here in Rockland, which is located in the South Shore. And I also want to indicate that I feel very confident that I also represent all of my neighboring towns in this region as well. I will keep my remarks very brief. Rockland currently has 4 fully executed, legally binding host communities, which were in effect prior to the law's effective date. The proposed social equity mandates on towns like Rockland are going to be incredibly burdensome and will force us to treat certain marijuana businesses differently compared to any other type of enterprise looking to do business in town or face state sanctions. It's another unfunded mandate on cities and towns, and it's simply not fair from a business or local government management and operations perspective. But most importantly, regarding the funding issue, I feel that I need to state the obvious, which is that revenue was absolutely a factor in voters' decision-making process when they voted to allow adult use dispensaries. For anyone to state otherwise, it's simply not true. The new burden you're proposing regarding our documenting costs and tracking staff time for each dispensary is not only unfair, it's also completely unrealistic. Towns like Rockland are simply not organized with the staff or resources to document the level of detail of actual costs for individual businesses the way you are proposing. In Rockland, our town meeting voted to place all HCA annual payments into a host community agreement special purpose stabilization fund. All of our spending from this fund is authorized by town meeting appropriations for specific purposes pursuant to a use of funds policy adopted by our Board of Selectmen. Our use and our accounting of these funds literally could not be more transparent. In my opinion, I think it's simply terrible public policy to move the goalposts and retroactively nullify our existing contracts, which have other government officials have explained. These existing contracts were voluntarily negotiated in good faith between both parties. These HCA agreements that we have were fully vetted by our legal counsel and were based on the state HCA templates that were available at that time. If your proposed regulations are adopted, this really will set a terrible precedent. It could affect local voters' decision-making in the future based on a lack of trust in state government that would most certainly and understandably result. Our local state senator and state representative have both confirmed that this was not the legislative intent of the law. Our state representative has already provided you with a comment letter for this public hearing, formally stating this for the record, and our state senator will be sending you his formal letter later today. So in closing, I would implore you to do the right thing and protect the taxpayers of the Commonwealth by implementing the 2-tiered approach recommended by the MMA. There would be the 1 tier for existing HCAs prior to the new law's effective date, which would be held harmless, and a 2nd tier for ones executed after the new law's effective date, which would be subject to the new proposed requirements. Again, thank you for the opportunity to speak. I greatly appreciate it.
Thank you very much, Mr. Lapp. And moving on to Sheila Green from the City of Boston City Point Neighborhood Association.
Not present.
Not present. Okay, moving on. from Sheila Green to Anna Albuquerque from Brookline.
Also not present.
Not present. Goldie Piff. Goldie Piff.
Goldie Piff, not present.
Okay. Get home tonight. Okay. Courtney Pereira. Okay.
Not present.
Okay, well, now I feel bad. Okay. Kevin Rudden from the town of Holliston. I believe he is with the Board of Assessors.
Thank you, Madam Chairman and Commissioners, for allowing me to speak. I'm speaking on behalf of the Massachusetts Association of Assessing Officers and asking you in these new regulations to correct a problem that assessors see cropping up frequently. In section 500.170 of your proposal, municipal requirements, you ask that all marijuana establishments and marijuana establishment agents comply with local laws. We would also like to ask that you put in there that they comply with Mass General laws by submitting the annual form of list, which is State Tax Form 2, and the annual expenses for all property types, which is DOR Form LA 38, to the assessors in the community in which they're located. While it's unusual to ask somebody to embed a state law in their regulations, what we find in asking for these documents, we have a large number of grow facilities in this area. What we find is the owners say, whether they're, by the way, individuals or large corporations, we've complied with this by submitting the info to the Cannabis Commission. So there's a confusion on their part that the local assessors also need these items in order to assess them fairly and equitably. And we would ask you if you would consider putting in a separate requirement into section 500.170, asking them to submit these forms, or excuse me, require them to submit these forms every year to the cities and towns in which they're located.
Yeah, please. Thank you. You probably are asking.
Well,
Go ahead, please.
Thank you, Kevin. Do you mind clarifying the forms? First, can you repeat the citations and then give us a little bit more clarity on the forms you're requesting?
Okay. State Tax Form 2 is known as a form of list. It is used by businesses to identify the personal property in their business and its value so that we can issue personal property tax bills. The DOR Form LA 38D is known as annual expenses for all property types. And since most commercial property is valued on what's known as an income and expense basis, it allows us to know the expenses that a business had during the year, which are deducted from their estimated income and used in calculating the property taxes for their buildings.
Okay.
Thank you.
Okay, thank you. Thank you, Kevin. And you have 15 seconds. Anything else you want to add?
No, thank you very much for your time.
Thank you very much. Ann Vandal from the town of Dragut.
Not present.
Thank you. Bram Goodwin. From San Francisco. Bram Goodwin.
Yeah, please testify.
Not present.
Not present. Okay. Thomas Dolan was here in person. Right, we haven't, has remote, he came in person. Okay. Rachel Doyne from Cape Cod Cannabis.
Not present.
Not present, okay. Whitney Monroe.
Not present.
Not present. Blake Mensing?
Hi, sorry, I'm actually driving and thought I would have already missed my slot. I had submitted some comments in the chat here. Let me just pull over so I don't kill myself here.
Do you want to?
Yes, so I'm Blake Mensing. I'm a former municipal attorney, I'm a cannabis attorney, and I hold multiple licenses. I've had.
Blake, why don't I skip you and we'll come back to you in 3 minutes and 10 seconds, okay?
Yes.
Give you a chance to kind of settle, okay? So I think that might make sense. So
Okay, sounds good, thank you.
Dying live on TV. So anyway, moving on
Sounds good, I appreciate
to,
it.
thank you. Moving on to Lindsay Scheckler from Acreage Holdings. Sorry, Chair. That's usually me.
Good afternoon. So since legalization in 2018, there has not been a wholesale revisiting of the regulations governing the market, despite significant changes to both the laws and the realities of it. So Acreage applauds the CCC for embracing its responsibility to draft rules that address significant deficiencies, specifically host community agreements. However, we are immensely concerned that the proposed rules do not specifically address the issue of oversupply. It's no secret that the cannabis marketplace is a bit oversaturated at the present time. There are so many growers in the space right now that many are struggling to compete amongst a noticeable oversupply. Currently, the amount of cannabis cultivated is at least 3 times the average monthly volume of cannabis cultivated and sold by all cultivation facilities in the prior year as calculated by the Commission. This is a problem. There are, however, some short-term solutions that would allow the market to get back on track. First, it is our recommendation that CCC consider halting licensing within the state until the oversupply is corrected. Secondly, we recommend that at the time of a license renewal, a cultivator shall provide inventory and production records for at least 6 months before the renewal application. As part of the license renewal process, the Commission should exercise discretion to reduce the licensee's maximum cultivation canopy to protect the market's sustainability. While oversupply is the true underlying issue here, Acreage does suggest a few other changes that CCC should consider that were provided in written comments. In short, these recommendations surround the definition of gross annual sales to reflect returns and discounts, not top-line revenue, and host community agreements, which include a suggestion on regulations that allow operators flexibility to maintain business operations, even if a municipality does not want to renew an HCA. I would like to thank the Commission members for their time today, and I look forward to our continued collaboration to ensure a successful cannabis program continues in the Commonwealth of Massachusetts. Thank you.
Thank you so much. Oh, hold on 1 second. Oh, Lindsay, there's a question for you.
Thank you, Lindsay. I just wanted to make sure I have my notes correct. You said gross sales should not include top line revenue, but can you just repeat that?
Sure. So, look right here. So the definition of gross annual sales to reflect returns and discounts, not top line revenue. So making sure that we are accurately reflecting that number.
Thank you.
You're welcome.
Hold on 1 second, Lindsay, you're popular here. We have one more question.
Lindsay, could you please submit your oral testimony to us, email, so I can look at it in written form, please?
Yes.
Thank you.
Yes, I will send it to you right after I hit you.
Great, and you know where to send that, commission@cccmass.com. Okay?
Yes,
Thank you.
Thank you.
All right, going back to Blake Mensing in parts unknown here.
Thank you very much. I am safely pulled over.
All right.
So yeah, as I was saying, I'm Attorney Blake Mensing. I'm a former municipal attorney and I've been a cannabis attorney since the inception of adult use legalization. I've helped negotiate approximately 100 HCAs in the state, including multiple of my own. And I applaud the Commission's draft regulations in large part. There are a few nits to pick. I'm sure that's not surprising. So yeah, I'll just rattle through them really quickly. I'm happy to answer any questions that may come up. There's a clause in the draft regulations that states that a local rule or bylaw will be given a presumption of reasonability with respect to the reasonably related community impact fee collection. I think that ignores the fact that municipal governments, go through the legislative process to enact zoning bylaws in particular that are routinely found to be unconstitutional. So I get that there's a presumption that municipalities are, acting in the public interest, but there are simply too many municipal legal matters to deal with. So they aren't, staffed with experts in cannabis law. So they often make rules that are on their face unconstitutional and would get struck down if they were challenged. The clause about whether the chief law enforcement officer, deems something reasonable, I think really ignores the fact that a lot of law enforcement subscribes to, disproven theories like the gateway theory, which is, scientifically not a real thing. So there may be a requirement that a local law enforcement official, imposes on a cannabis company that isn't based in science. So I don't think that's a fair presumption either. I just wanted to respond briefly to one of the comments by the Athol town administrator earlier on today in person. He said he felt like the rules shouldn't change and there was a promise of financial benefit from the cannabis industry. That is 100% wrong as a matter of text, right? The original statute on the HCA community impact fee was clear that the impacts had to be reasonably related, the costs thereof had to be documented, and the actual documentation became a public record. So there's also longstanding case law that says a municipal fee can't be net positive. You cannot make money on a municipal fee. So I've seen myriad HCAs that had a clause that would say, this money is 3% no matter what, and that goes to the general fund. And we can spend it however you want, and the operator doesn't have the chance to challenge that. The fundamental thumb on the scale in terms of unfair bargaining power is precisely because municipalities know that an applicant needs an HCA to even become an applicant, and no municipality needs any particular applicant. I also wanted to respond to what the Mass Municipal Association representative said, that this state is dominated by multi-state operators. Well, that's because under the prior statute, towns would hold bidding wars of who can give us the most benefit above and beyond the community impact fee. So here's a fire truck, here's a playground. The people with the deepest pockets won those races to the HCA finish line. So it's really rich, in my view, for the MMA to be complaining about that at this point. The sort of thing hanging over the industry with respect to what Alyssa Nowak mentioned earlier, where if an applicant enters into an agreement with a community and it's not compliant with the statute, the remedy is discontinuance of the relationship with that municipality. Let's say they've been in operation for 5 years. If the town can't understand what the new statute says, this isn't dense text, just figure it out. Charge what's actually reasonably related and nothing more. Why is the operator left holding the bag? The cost to get one of these facilities open is astronomical. So I think there's a fundamental misunderstanding by municipalities that the community impact fee was meant as a blank check. You cannot make money on a municipal fee, and that's clear. The last thing I'll just mention is, as we all know, there's multiple pieces of pending litigation under the prior statutory text about what is and was not allowed to be collected as a community impact fee. That decision, those various case decisions by the judiciary will define what, answer the question of retroactivity. The prior statute, again, was really clear. I think the MMA, the state's largest municipal law firm, manufactured ambiguity around that to say, it says up to 3%, but then they ignored the rest of the statutory text. That's not how you read a statute, and I think they know that. One quick anecdote, I was negotiating an HCA for one of my own companies, and the attorney from that largest law firm said, I want a separate development agreement with your real estate holding company because I don't think the statutory prohibition on getting more money out of a cannabis applicant applies to a separate entity that holds real estate. So what I said is, okay, if you want to have that cute reading of the statute, I'm going to put my real estate in my applicant entity's name, and then you can't play that game. They also included a clause in that draft HCA that they knew to be impermissible because its president is not allowed to be in an HCA in guidance documentation that they sent to their own municipal clients. So I think there's a lot of hemming and hawing and sort of crying about, oh, we negotiated these in good faith and we should be able to get the benefit of the bargain. But any contract that's set up to 3%, no questions asked, I think violates the prior statute, and we do have the benefit of the judiciary telling us if they agree with that.
Okay, Attorney
I'm very confident that the plaintiffs will win that.
I'm assuming, Attorney Mensing, that because you are at the wheel, you can't see the light flashing. So anyway, thank you. The additional information that went over 3 minutes was frankly very helpful, so we appreciate it. And We hope you have a good long weekend.
If I may just say one last thing, if I can.
Okay, 20 seconds.
Just real quick. The fact that the city of Boston voluntarily returned millions of dollars of community impact fees collected, I think is really telling. Boston of all municipalities is in the business of walking away from money. So I think they knew they were subject to massive liability. So any town that spent money collected under the prior statute already, I think, and it wasn't due to offset an actually incurred cost, I think they're going to be left holding the bag. But that's clear from the new statutory text that was the whole point overall. So I appreciate it.
Thank you. Thanks very much. We appreciate it. Next to Eugene St. Pierre from Cosmopolitan Dispensary.
Not present.
Not present. Okay. Elisa Brewer.
Yes, thank you. My name is Alyssa Brewer, and my camera's not working well. I'm just going to turn it off. I was an elected official in the city known as the town of Amherst for over 20 years, and I retired at the end of 2021, so I'm absolutely only speaking on my multiple experiences with the regulated cannabis market, both medical and adult use, not on behalf of any town. I'm no longer an official. In my former capacity, in addition to my extensive work on both zoning and general bylaws within the town, I also testified multiple times before both the Cannabis Control Commission and the legislature via the joint committee. And over the years, I've submitted numerous redline versions of proposed legislation and regulations, in addition to enthusiastically serving on the first Cannabis Control Commission Social Consumption Working Group before you guys were there. That context provided, I hope you can hear my comments today as adding light instead of heat. I share the passionate belief that we all have good intentions to build on the equity and empowerment work that's been driving this entire regulated market from the beginning. And based on my 20 years of experience, municipalities are not the bad guys here. Sure, there was one visibly bad actor, but hey, that's been true of Massachusetts government work, elected and appointed since the beginning of time. We all know there are well-resourced out-of-state investors in this market, and they can always outcompete local investors because capitalism. So while all the municipalities I've interacted with over those years embrace the theory of social justice and economic empowerment, they really had very little idea of how to implement those values. For years, municipalities, and please remember there are 351 municipal governments in our beautiful Commonwealth, most of which are not big cities, but are instead run with very little money, very little staff, and largely volunteer elected officials. Municipalities were really struggling in the dark to figure out the difference between the impact of adding just another liquor store versus the impact of a new cannabis retail outlet. And please note that municipalities cannot tax each bottle of wine or handle of vodka, but given the opportunity, particularly in a college town like Amherst, overrun by Forbes last spring, responsible municipalities do feel compelled to collect every possible fee and tax legally available to them. That to me is the definition of good faith in this conversation. Municipalities need real model documents, not just general considerations to work from. And we were not provided those by the well-resourced Cannabis Control Commission. And while you may not consider yourselves or your predecessor well-resourced, if you talk to any small town administrator, you'll hear differently. So it's really no surprise we ended up here. What we all need moving forward is faster Cannabis Control Commission action, which I know you're all working on, and better guidance, which I know you're all working on, not bigger penalties, and certainly not retroactive penalties. Of course, it's outrageous that a new business should have to pay months and years of rent before opening, but the problem is not greedy towns. The problem is municipal officials have not been given adequate tools to implement the values we do in fact share. And one of the biggest tools that we found so important in the first social consumption working group was pre-certification of applicants by the CCC before any applicants even seek an HCA from a municipality. So anything you can do toward making that happen for all applicants, not just the glacially slow rollout of social consumption licenses, would be wonderful. Thank you all for your time and your work and letting all of us from all different aspects of this problem come and speak to you today.
Thank you very much. We appreciate it. And next is Rob McKenzie.
Not present.
Not present. Moving on to Kevin Gilnack, Equitable Opportunities Now.
Thank you, Chair O'Brien and Commissioners and staff. My name is Kevin Gilnack, and I'm the co-chair for Equitable Opportunities Now. nonprofit that's been fighting for a more equitable industry since passage of question 4. As a former member of the ballot question drafting committee, I really appreciate all the hard work that you and your predecessors have undertaken to get us this far. And as one of the approximately 6,000 people pardoned by President Obama for having a simple marijuana offense, someone who lives in and advocates for communities harmed by the war on drugs, I'm really grateful for your commitment to the CCC's equity mandate. I want to thank you for your inclusive and thoughtful process, and especially thank each of you for attending EON's listening session in July. And I just want to set a little background. We're here in large part thanks to 2 women on the Question 4 committee who saw the greenwash and profiteering that was going on in other states before mass, and saw an opportunity not just to stop a racist and unjust policy and create a new industry, but take steps to undo that harm. In doing so, they helped make Massachusetts a model for the nation. And I know that folks are going to be watching what we do with these final regulations for guidance in their own communities. So I want to shout out EON co-founders Chanel Lindsay and former Commissioner Shady Title for all the seats they've planted going back all the way before 2016. But another reason we're here is because of a policy and political choice that the ballot might have provided an easier lift for regulators and a quick path for consumers to get products. It came at too great a cost of strangling efforts to promote an equitable industry. The 2017 amendments by the legislature prioritizing economic empowerment applicants along with medical treatment centers provided too little too late as MTCs and their advantages proved more appealing to funders, landlords, and many of the host communities that we've heard from today. If we're truly going to create a more equitable industry, then we need to acknowledge the systemic barriers and harms that we're trying to undo. Which is why I raised this, as well as a reminder for other advocates and legislators both in Mass and around the country to put equity first, even when it's politically hard. The good news is we've learned from those lessons, and we have a lot of creative and passionate commissioners, advocates, and legislators who aren't going to let us be tied down to the past. And I want to urge the Commission to take advantage of the new prerogative granted by the legislature under Chapter 180 to remove the inequitable and outdated and no longer relevant MTC prioritization from the regulations, using the new authority to prioritize economic empowerment and social equity participants, which was codified into Mass General Law, unlike the 2017 session law that prioritized MTCs. I further urge you to strengthen your language regarding licensing ratios. As you heard in our listening sessions, licensing ratios are a very effective and straightforward means for ensuring more equitable market participation. The City of Boston has been very effective in implementing such a ratio for several years. We're glad that you've encouraged one for cities and towns looking to increase or eliminate the previous caps, and we urge you to expand that language to include all cities and towns. And we further urge the Commission to take the same type of leadership, model and leadership on that, and set the same requirement for state licensing as well. We have significantly more suggestions for you to consider in written testimony, and I'll be submitting shortly. Thank you for your time.
Thank you very much, Kevin. We appreciate it. Right, moving on to Barbara Gonzalez.
Not present.
Not present. Marcia Pinnock.
Yes, hello.
Hi, Marcia.
Yes, hi.
You can begin. Are you trying to pull up her visuals? Hold on.
I wasn't speaking. I was just actually viewing today. I didn't know you had to speak.
Oh, you don't have to.
Okay.
We're happy to have you, Marcia, anyway. Nice to see you.
Okay.
Thank you. Moving
too.
on, you just saved us 3 minutes. Thank you, Marcia. And we've already had Alice Brewer, Ellen Brown. Man, just a lot of listeners here. Okay, Ellen Brown. Oh, there she is. Sorry, Ellen, I was too fast. Okay, sorry about that. Hey, Ellen.
Thank you so much. I appreciate all of your time. Thank you, commissioners. Thank you, Chair O'Brien. I'm here today to give feedback on the removal of specific mandatory disqualifiers and my concern with those mandatory disqualifiers being removed. I understand that these changes are mandated by law, but the CCC does have the ability to invoke your legislative outreach strategy to ask lawmakers for targeted changes for public health, safety, and welfare. The Cannabis Control Commission voted unanimously to remove the mandatory disqualifiers for certain convictions, including human trafficking and all level sex offenders, both registered and unregistered. I would have appreciated if those mandatory disqualifiers, because they are itemized, could have been red itemized, and then if there could have been more data and more information given on how removing those specific mandatory disqualifiers is going to be for the betterment of the industry, and with the focus on public health, safety, and welfare. And I was wondering if we are going to have the conversation of how the mandatory disqualifiers will be removed for sex offenders and human traffickers, but not for those with cannabis convictions in the cannabis industry. I think that of all the things that we could do to be impactful in the industry, some of the things that we are, not fully living up to are the programs that the Cannabis Control Commission created to ensure that we would have a diverse workforce. This includes the implementation of the leadership rating program, which was included in the draft regulations, but is still yet to go into effect, acknowledging those that hire locally for local employment leader, social justice leader, acknowledges those that hire diversely, holding MTCs accountable for their diversity plans, which it has been said that they are not meeting. And I do feel without the incentive of the leadership rating program, that there is a correlation and a causation to those not being met, and it's a problem that can be fixed. There is a need for the Cannabis Control Commission to focus more on OSD certified businesses, aka disadvantaged business enterprises, and having more diversity among licensing types could help to promote diversity among employees. Looking at our numbers from August 2022 to August 2023, the Cannabis Control Commission has certified 0 disability businesses in the last year, 1 LGBTQ+, 5 veteran, 6 women-owned, and 23 minority-owned businesses, which 23 sounds good, but when you think about it, that's less than 2 minority-owned businesses being certified a year. We can do better. So just thinking about wanting to focus more on those programs. And then my final thoughts are, when it comes to sex offenders working in medical marijuana establishments, no matter how this works out, I really want that to be focused on, because I do worry about the focus of MTCs on the pediatric population. Even though the pediatric population isn't present, there's still a focus on it. So just looking at variables and just thinking through that more thoroughly, as well as thinking about with human trafficking. Human trafficking is a human rights violation, and something that other states like Oregon and Vermont have included in their core curriculum to train their workforce about reporting procedures. Thank you very much for your time, and just so the commission knows, some people did get into the industry because of those specific mandatory disqualifiers that are being removed when it comes to all level sex offenders and human traffickers. So I would hope the commission takes time in thinking if those would be something they would be able to continue to have as part of the mandatory disqualifiers. I support keeping telehealth for medical patients. I thank you for your time, and I will be sending in more commentary.
Thanks so much, Ellen. I'm glad I didn't blow past you here. You did a nice job. Thank you. David Jean-Jacques from Big Hope Project.
Hello, Harry Jean-Jacques here, Big Hope Project. Distinguished members of the Cannabis Control Commission, thank you for allowing me the time to speak today. My name is Harry Jean-Jacques, founder and president of Big Hope Project, a 501c3 nonprofit organization representing returning citizens and communities disproportionately impacted by the war on drugs. As an organizer and lifelong resident of a disproportionately impacted area with experience advocating and implementing local equity ordinance in Massachusetts, namely in the city of Boston and the city of Cambridge, I cannot emphasize enough the importance of prioritizing municipal equity in cannabis licensing to prevent ongoing disenfranchisement of African Americans, the primary targets of the racist war on drugs, and their lack of participation to benefit from this industry. I urge the CCC to look at the examples of Cambridge and Boston, 2 cities implementing equity within their cannabis regulations. In Cambridge, a commendable 100% equity ownership requirement has been established. This means that all cannabis businesses in the city must have a significant ownership stake held by individuals from communities historically impacted by the war on drugs. By implementing such a policy, Cambridge has shown a genuine commitment to remedying the injustices caused by past drug policies and ensuring that those who were disproportionately affected have a real opportunity to participate in the cannabis industry. On the other hand, Boston, while making strides toward equity, currently has a 50% equity ownership requirement. While this is undoubtedly a step in the right direction, it falls short of the ideal goal of full equity ownership. Nevertheless, it is encouraging to see Boston acknowledge the need for equity and take action to address it within the municipal licensing process. However, much work still needs to be done at the state level. The Cannabis Control Commission is responsible for upholding its role in providing equitable access to the cannabis industry. According to MGL Chapter 94G, Section 4A4, Massachusetts must promote policies and procedures that ensure all the participation, procedures that ensure the full participation of those disproportionately impacted by the war on drugs. Unfortunately, the CCC's current ownership demographic statistics indicate a failure to meet this obligation over the past 7 years. The CCC must take immediate action to rectify the situation. They must actively implement regulations prioritizing equity in municipal licensing and HCA negotiations. This includes reining in out of control HCAs and community impact fees that may disproportionately burden equity applicants, making it difficult for them to enter the industry. I recommend that the Cannabis Control Commission implement a statewide cannabis municipal equity priority period for the next 4 years to ensure that the CCC upholds its promise to those systematically marginalized by both the war on drugs and legal cannabis framework, to allow social equity and economic empowerment applicants to gain a tangible foothold in Massachusetts' legal cannabis market. In conclusion, the current state of equity in the cannabis industry in Massachusetts demands our attention and fierce, unprecedented action. By acknowledging the failures in upholding equity, citing specific examples from Cambridge and Boston, and making bold policy adjustments to prioritize equitable access, we can create a more just and inclusive cannabis industry that reflects the principles of fairness and opportunity for all. Thank you for your time.
Thank you so much. And I just want to clarify, I have on my list as David. Are you David or Harry?
I'm related. I'm his brother, but it was a clerical error.
Oh, all right, okay.
Same organization. Thank
Okay,
you.
so you're Harry. Thank you. You're David.
No, I'm Harry.
You're Harry, okay. I just wanted to make sure. I have two names here.
Store Harry and David.
Harry and David, yeah, we got that, yeah, we
Yeah.
got that, yeah. Your mother had good taste.
Thank you for your time.
Thank you very much, sorry. Woo, we're getting through here. Okay, Pat Neary? I just want to make sure that Pat Neary knows that he or she has an opportunity to testify. And again, just want to make sure if you're just listening, we know you just want to listen. How about this? I'll give it one more second here. Pat Neary?
We'll double check with the Zoom and we can circle back.
Yeah, I will move on to Charles Carey from the town of Brookline, and we will go back to Pat Neary after that. Thank you. Charles Carey from Brookline.
Thank you very much. I'm Chess Carey, Brookline's town administrator. Thank you very much for the opportunity to testify and for all the work that you and your staff do. We welcome the changes to the statute and your commitment to equity that Brookline shares. But I'm here, as many of my colleagues in various towns and cities across Massachusetts have been here, to urge you to revise these draft regulations because they're a massive overcorrection that will not do what you want them to do. Brookline was the first community in the greater Boston area to welcome cannabis retailers, and we look forward to our continued partnerships with those retailers. But if these regulations are adopted as is, Brookline will likely be unable to welcome any new equity applicants. Instead, we will have to consider leaving the cannabis business altogether. I'll refer you to my written testimony for details, but let me summarize the basics. One, the interference with settled municipal contracts. I understand that the retailers shaped these agreements. Frankly, Brookline, like Pittsfield, wants to move on from HGAs to a more normal licensing scheme that treats cannabis businesses like any other. But interference in existing municipal contracts is not just bad public policy, it's unconstitutional. To Mr. Mensing's early point, if municipalities' agreements were already unlawful attempts to generate revenue, That can be and is being litigated already. Whatever retailers may want, the proposed regulatory language is simply not allowed. And Brookline would likely be one of the many municipalities that would seek to enjoin any such attempt to do that. 2, vagueness about licensing versus HCA. I understand the commission has said unofficially that communities can license retail cannabis businesses, impose reasonable conditions for licensing, and charge reasonable fees for a license. But that's not in these regulations. In fact, they repeatedly confuse the concepts of HCAs, local licenses, and licenses that you, the commission, may issue. You should make clear in these regs that communities can license cannabis businesses, impose those reasonable conditions, and charge a reasonable fee in line with the Emerson College decision. Retailers tell us they want to be treated like package stores. This is what package stores do to get licensed. 3, limitations don't count as reasonable expenses. We were pioneers in retail operations, and we have been at the forefront of developing policies and procedures to ensure those operations are orderly and that they can lead to success for retailers. We spend a lot of time and money doing so. We estimated that last year we spent the equivalent of 1.5 full-time employees' full yearly hours just to deal with cannabis-related issues. Under these new regulations, those efforts could no longer be recouped. Now, we estimate that number is going to go down over time, but it's still with us today. Eliminating that ability now means that we will effectively be subsidizing cannabis retailers at a level we do for no other business. 4, fee invoicing. The regs give municipalities a 1-month deadline to submit fee invoices and retailers 8 months to pay, assuming they don't contest the invoices. You're talking about injecting 2 or 3 fiscal years worth of uncertainty in municipal budgets. That is unworkable, and I strongly urge you to consider a fairer and more streamlined process like the one outlined in our written testimony. Finally, under the current regs, any, quote, interested person, unquote, can lodge a complaint with you about a municipality's equity licensing policies, procedures, and decisions. So any resident could lodge a complaint with you and gum up the works. Anti-cannabis advocates, for example, could try and prevent a qualified equity applicant from opening under the guise of equity concerns. The same way anti-housing advocates use environmental laws as a cudgel against density that would actually be better for the environment long term. Please limit the ability of bad actors to place barriers to entry for equity applicants. Thank you again for all the work that you do. We very much appreciate it. We look forward to working with you and the cannabis industry to, as many people have said here today, normalize the industry and treat it like any other. Thank you very much.
Thank you so much, Charles. We will go back to, was it Pat Neary? Pat Neary, that was the last name, right? The name before his. Do we have Pat Neary? We still have Charles up there. I applaud the staff for the.
Yeah, it says that he's present, but we reached out to chat to see if we can get him up so we can move on to the next one. We'll loop around.
Reached out to Neary, to Pat Neary?
Via chat, we're waiting to get a confirmation that he's going to speak.
Oh, okay, all right, I'll just move on. Okay, we're actually making a lot of progress here. This is good. Stacy Wojtrowski from the Cannabis Workers Resource Group.
Not present.
Not present. Brandon Pollock from Theory Wellness.
Not present.
He sent testimony this morning. He sent testimony, okay. We still have Charles up on our screen here that I can see, so I don't know if that means anything. Erasti Phillip.
Not present.
Not present. Juwan Skeens, who is a candidate for Boston City Council.
Present, how are you?
There you are, okay. Hey.
Good evening. Sorry, everybody. Give me 1 second to get settled here. All right, yes, good afternoon, everyone. My name is Juwan Skeens. I am a write-in candidate for Boston City Council at large. I am also a 29-year resident of Dorchester, born and raised inside the city of Boston. I am just wanting to speak on a few comments. Give me 1 second as I pull up my notes here. The first thing that I definitely want us to tackle is in regards to transparency around the community host agreements. when we are going into communities and providing presentations with our business owners. A lot of community members don't know what a community host agreement is and what the options are for them to choose from. So we're able to have a slide available providing information around the implementation of different agreements across Massachusetts. That would just give people better insight. Additionally, I know that when the Cannabis Commission was started, there was conversation around the tax dollars being created to be focused on education and transportation. One thing that I would like to see done is that we are investing into child care vouchers for families in the disproportionately impacted areas. I would like to see us investing in new books for Boston Public School kids. I would like to see us paying for school lunches for our kids who are unable to afford lunch. And then, definitely I want to see us continue to investing into nonprofits and after-school programs to help keep our children safe. And on the transportation side, I want to see some community bus monitor positions through the state and city, as well as crossing guards for our kids when crossing the street. And I guess I will end on this last comment saying I want a clearer, more affordable social equity application process to make sure that we're balancing out the representation of cannabis shops opening across Massachusetts. If you guys have any questions, you guys can, reach out to me. I'll put my campaign email, schemesforboston.com or schemesforboston@gmail.com is my email. Schemesforboston.com is my website. If you guys have any questions, I look forward to working with you on the road ahead. Thank you.
Great, thank you. Get back to knocking doors. Oh, you've been there. Okay. Any luck with Pat Neary, or have we?
Not yet, no.
What?
We have not heard back yet.
All right. Then Patricia Cooney from DPH.
That one also says present.
Hello, I'm here.
There we are.
Hello?
Hey, Patricia.
Yes. Can you hear me?
Yes, we can. We can't see you, but we can hear you.
Okay, I'm at work. I have a lunch break.
Oh,
Anyway, thank you for your time. I appreciate this opportunity. I just wanted to support Jeremiah McGinnon and Frank Shaw and their efforts for telehealth for medical cannabis patients. My total focus is on medical cannabis patients. I have a very sick daughter. I'm a caregiver, I'm a nurse, I'm a school nurse, and I'm a sexual assault nurse examiner for the Department of Public Health. I'm also a recent graduate of University of Maryland School of Pharmacy, Medical Cannabis Science and Therapeutics. And also we do have students that are starting to come into our school on cannabis for different neurological things, and that should be able to be administered in the school setting if it's prescribed. I know we have students, one student that's on a study from Children's Hospital, also people who have medical conditions and have their certifications to not be penalized for that. So those are my concerns as a healthcare professional and as a mother of a severely sick adult daughter, and the telehealth would be beneficial to me as our family. I'm also a grandmother raising a grandchild. My disabled daughter has a child that we are raising too, so my husband and I still both work. And for her, we have so many appointments for her medically, and also to manage my 9-year-old grandson to make sure he gets all his appointments. So people with these medical conditions have very complex social dynamics in their home. And it's very impactful, and to ease those burdens, I mean, and also that would be very helpful to continue the telehealth. And also, when my daughter had her 2 hips replaced, I could go into CVS and get her oxycodone. But as a caregiver, I have to show my license in my caregiver card 3 times. And cannabis hasn't killed anybody. It is a medicine. I actually, we have quite a few graduates from the program that are healthcare professionals in Massachusetts, and we want to do a lot of educational initiatives actually with the Cannabis Control Commission. Number one, I'd like to really teach about the endocannabinoid system. If you're on the Cannabis Control Commission, you should be aware that we do have a system in our body that's only taught in 13% of medical schools. And as a nurse, nursing has been supportive of medical cannabis for 27 years. And the National Nursing Board has 6 domains of knowledge that nurses should have. And I have students coming into my office all the time, and I teach them about it. And they're not being taught in the schools. So this is a system that's in our body that needs to be taught. And it's got nothing to, whether you agree with medical cannabis or not, or cannabis, it needs to be taught. It's here to stay. It is a medicine. It was in the pharmacopedia till 1942. But as we know, there was a power play with that. I'm just trying to get all my points in. And I've started to collaborate with the Massachusetts Patient Advocacy with Jeremiah and Frank. And they're doing good work, and they do it in a methodical and a very kind and concerned way for the medical cannabis patient. And they're a good voice for them and the concerns that we have for medical cannabis patients, and it should be covered by insurance, which it's not. I mean, we spend $300 to $400 a month on my daughter's medicine, and we should have healthcare guidance in the medical cannabis space because they're left on their own. And then actually to go into a space like my daughter's in pain all the time, to be in a space where there's people of recreation who are looking for a good time, which I have nothing against that, but people who are sick need help and they need to be prioritized. That's how medical cannabis got here in 2015. I was at the first opening of the first medical dispensary in Salem, Mass. That's what provoked me to get more educated and understand what's going on. I couldn't go in with my daughter. The police were there, very sick people with Parkinson's, shaking. I just encourage you all to watch Dr. Rachel Knox, KNOX, 15-minute TED Talk, medical cannabis, great 15-minute talk about endocannabinoid system. Also, the Massachusetts Medical Society now endorses medical cannabis for the relentless efforts of Dr. Uma, Harvard-educated doctor. Also, Dr. Dustin Sulak in Maine. He is a medical cannabis expert in the world. His website, healer.com, is very instructional, medicinal. He is sought after at the conference. Their conference, Cannabis Coalitions, is going to be going on in Rhode Island at the end of the month. So there's a very rich community of medical professionals who are trying to help medical cannabis patients. And I would love to collaborate with the Cannabis Control Commission I'm an expert now in medical cannabis. I graduated, all my instructors were pharmacists.
Patricia, if I could, we've allowed you to sort of go beyond the 3 minutes because you and I have talked before. I know your story. I know the story about your daughter. I fully appreciate the expertise that you bring to the table. And I would like to continue the conversation because this is actually something that a number of us are going to be talking about going forward with the reclassification potentially, or at least that's what's been floated in the press, of cannabis under the FDA. There may be some additional opportunities that allow us here in Massachusetts to do much more in terms of medical research. And so we will be convening some groups to look at that, to look at how we can promote that here in the state, to get some support from the legislature for this. So anyway, Patricia, I promise you that we will reach out to you and take advantage of your expertise on this. So we thank you. And again, you and I have talked before. I appreciate all the work that you're doing, and thank you for your expertise on this. And if you do want to send in anything more in writing, it's commission@cccmass.gov.
I will do that, yes, thank you.
Thank
I
you.
appreciate your time and thank you for giving me the opportunity, I appreciate it.
Thanks so much. We appreciate it.
All right.
Okay, so everybody else is gone?
Yes.
Okay, no, we only have one person. We have the last speaker. Diego Bernal is our last.
Yeah, thank you.
Hey, Diego.
I appreciate that. My name is Diego Bernal. I'm a co-owner of a locally owned and operated vertically integrated medical and adult use tier 3 small business in the South Coast. After 4 years of local and CCC approvals, we've finally been open for 11 months. Rough 11 months, but we're finally open. I have direct experience with the HCA and negotiations and the impact of that. So I'm trying to put a face behind what has and what is happening. To be clear with no certain terms, our negotiation with our town relative to the HCA was very discouraging. It was made clear from the start of the HCA negotiations with our town years ago via the town council that the town was intended to extract as much financial gain from our company as possible, and many times seeming to even ignore some of the early guidance issued by the CCC on HCAs. Our original HCA negotiations happened, as you know, before we opened, and we need those HCA documents signed before we continue the licensing process. My lifetime savings, years of work, tons of stress, were on the line if we didn't reach a negotiation for HCA with our town. So we really had little choice but to accept the town's demands, one in particular, which was this flat 3% community impact fee, or CIF. Well, I believe that this is exactly what the CCC was trying to avoid. It did not work in our situation, as we had to sign a very unfavorable HCA. 1 month before we began our commenced operations, the governor signed the Cannabis Reform Bill based Chapter 180 of the Acts of 2022. In short, part of this new law states that the fees demanded by municipalities should be usually related to the actual costs imposed upon the community. We recently met with our select board to tell them how our business is doing. We are locally owned and operated, and how things have changed since we started. The industry has completely changed with competition, with oversaturation, and with a market downfall. In particular, we wanted to address some relief from this flat 3% CIF fee. Well, we were willing to pay, and we are willing to pay anything that we cost the town. We learned that we have cost nothing to the town. There has been no extra cost to our town. If we pay this extra fee, we may not survive. So to make it short, but I don't use all my time, what we're trying to have the CCC clarify is that the changes to the CIF or parts of that HCA should be implemented after November 9th change in the new law, not in March, which gives the town another 1.5 years to continue to do what they want to do, offer no evidence of what we're costing them, and continue with that fee. We're not a big company. We may not be able to survive and sustain this and offer our medical and adult use customers that. So please clarify when this is going to be active, because the town really doesn't think it's retroactive and we're going to be abiding by the old HCA until something happens. Thank you very much for your time.
Thank you. Oh, go ahead. Thank you. We have one question, please.
Diego, thank you so much. I hope this is a quick question. You mentioned that you entered your HCA, I'm sorry. Hi, Diego, can you hear me now?
I can hear you.
Okay, perfect. What month did you enter your HCA?
We entered HCA, I'm going to say March or something prior to the November change in the law.
Okay.
2022?
Okay. That was it. Thank you, Diego.
I'm going off memory right now because everything's happening, but it was before the change in the law when we finalized our HCA to continue the licensing process with the CCC.
Okay, thank you.
Thank you. Okay. So now what do we do? So just sort of bringing this to, the testimony to a close. I'm a little nervous because we still have testimony that's coming in until 5 o'clock tonight. I think that we have a lot of confidence in the work that's been done to put these drafts in place. However, I've noticed everybody taking notes, and maybe you have been persuaded by some of the testimony in one direction or another. So next week, the next meeting that we have, right, is Thursday, the 14th at 10 o'clock. And then the following week, the 18th. But one of the questions, and I was speaking with Attorney Baker yesterday, and Attorney Baker has been just amazing. In addition to having a new child and coming back and doing this, he's been really holding our feet to the fire in this tonight, and I really appreciate some of the work that he's done, that Andrew's done, Mercedes and other people have done, Megan and other people have done on this. But what I get a little bit nervous about is, how are we gonna do this in these next 2 meetings? You know, it's, and I wanted to just get your feedback, because is it as we did it in the July meeting with the draft? Should we just go line by line, maybe all of us taking notes or commentary to debate any of the input that we've received, feedback that we've received as to whether or not we think we're in the right place on the draft, debating how or why we might make changes. You know, then we have the Monday meeting and we could vote on that, or it may extend into that. I guess I just wanted to kind of get your sense, because I've never done this before. We have some staff who have done this before, but it's my understanding that this is being put on us to make these decisions. And I'm still a little bit unclear about how, I mean, you've done regulations live and done this, and so maybe Commissioner Stebbins, maybe give us, you know, some of your insight on how you think, because one of the other things I was going to suggest is, if we need to spill over into the 19th, that's pretty much it. We are dead against you know, we've started late on this. We now have a very hard deadline. Now, remember, we can always fix this, right? Not that we want to, we don't want to do this, but one of the things that I'm hoping, and again, this is me, we haven't voted on this, but I'm hoping that we can, as a commission, have a standing and ongoing regulatory writing process that never closes, that we're constantly reacting to the changes and the tweaks that we need to make. Head explosions aside, you know, I want to make sure that we can do this. So I wanted to throw this out to see how all of you think that we can and should be doing this, but also saying, if we need to spill over into the 19th, that we give ourselves at least that. I mean, I'm a couple of meetings. I don't know if anybody's traveling or doing anything, but I just want to make sure that we don't try to get this done under a tight deadline that we've kind of gotten to, and then we don't do it right, we do it faster. So I kind of, maybe Commissioner Stebbins, you can kind of give a little bit of your insight and give me some guidance, because I'm sort of, this is without a manual here, I don't know what I'm doing, so.
No, it's a great question. Obviously, we've heard a lot from a lot of different people about regs that we're currently changing, about regs that we might anticipate changing at some point. I would throw out maybe 2 recommendations. First of all, there's a lot that I want to go back through based on what I've heard today. I also think it might be appropriate if the working groups themselves wanted to reconnect and sit down and go through some of the feedback. And those working groups have been closer to the reg work than those of us not in the working group, but might want to sit and consider, we heard a lot on this, we heard a lot on this topic. Is it something we can change, or is it something that we can't change just based on what the statute tells us? So kind of that 2 direction. Individual commissioners, go ahead.
I'm sorry to interrupt, but what I'm more concerned about is the stuff that I haven't worked on, that I am less, you know, you've had the benefit, Commissioner Concepcion, of working on 2 of the working groups that we're dealing with right here. So you're kind of an expert on both.
3,
yes,
suitability.
Right, with suitability. So I feel like I know as much about the sort of equity process and what but I'm a little bit less expert or solid and grounded in my understanding of some of the language, which frankly is probably the most controversial, which is the host community agreement. So that's why I'm just saying, you know, and this is again, would it be a meeting if I didn't complain about the open meeting law?
Sure.
But, you know, this is the problem that I have, is that I would like to be able to talk to the people who sat there, who drafted it. I mean, we walked through it and we went, okay, this is a draft. But I'd like to really dig into, you said this, and I heard this mayor say that, and I heard the MMA say this, and I've heard a licensee say that. I'd like to sort of get the people on each
working
group to defend that decision, not defend, but to reinforce why the decision initially made was right.
Yeah. Madam Chair, if I may, so a couple of things. One is, I think we have Andrew available on Teams for some historical perspective. Two, operationally, I think even though it takes a while, but I think what we did last time that we went sort of section by section and kind of had the discussions, and some of them we knew they were deeper. Right. I think that would be another way to do it as well. The working groups, I don't sit on any of the working groups right now, so I don't know that process, but I can imagine that working group members, after hearing all the comments, and really, I say this all the time, none of us run businesses, at least cannabis businesses right now. So, hearing from operators and hearing from municipalities, this HCA is a big deal. The reform was a big deal. We got to get it right. We got to find the balance, because yeah, we can fix it, but no, we can't, because the regulatory process does take a while. So I think that, but we are tight. So I would also recommend looking at our calendars as well. But that's sort of my take, and I know that Andrew's also available for.
Okay, if attorney, go ahead.
Chair, what about the 5th? Meeting Thursday, meeting Friday the 15th, meeting Monday, Tuesday if we have to.
Hold on just 1 second. Yeah, if Attorney Carter would like to join us, is he in the building or is he remote? He's remote, okay.
Yes, Madam Chair, I'm here. I would suggest that I'm aligned with Commissioner Stebbins' suggestion as it relates to involving the working groups to reconvene with their commissioners and review the comments. Ultimately, where we are in the process, I think that if the commissioners want to suggest changes to the draft regulations, that we do that at a public session so the commissioners are able to debate the merits, and we will either accept them or not accept them based on consensus of the body, and then we will have the ability to promulgate the regs. So a very similar process to what we engaged in July.
Please go ahead.
Attorney Carter, based on that scenario, will we be making live edits? So if 3 of 5 agree a change needs or tweak needs to be made, are we doing this real time? We're making live edits to these draft regulations?
Commissioner Roy, that would be correct.
Thank you.
All right, hold on just a second. I'm just worried about posting. Okay, so you started before Attorney Carter spoke. You were talking about, and I'm sorry that this is so.
It's okay.
Clunky to.
Well, we have a meeting on the 14th. We have a meeting on the 18th. You propose the 19th. Do we need another meeting on the 15th?
Well, let me tell you, and this is, I'm getting a little, how are you going to do this? So I think that because we have to notice this, right, and it has to be 48 hours, we can notice.
So we have time.
Right. Yeah. So my sense is I'd like to take the time, maybe the individual working groups can kind of reconvene, but from my perspective, I'd like the working groups, I would hope that the working groups could go absorb some of the testimony that we've received in writing, in verbally today. And then we come back as an open group and either you have said, wow, we had the group and maybe I missed that point, or, maybe this is something, I mean, I heard some stuff about our group that I think I might, want to.
And Madam Chair, are you envisioning that when the working groups had that conversation, that then you all as representatives of the working group come back and sort of give us some new
What I think is I think the working groups, because they're the experts on their particular topic, need to kind of, and again, if you think I'm wrong on this,
no, we're walking through it.
What I'm saying is that walk through it and sort of maybe go, yes, no, we believe that, well, that maybe makes me rethink. And then we come back as an entire body to then walk through, and then I can ask some pointed questions about HCAs based on the decision that the HCA working group has made. And then you can tell me why you are convinced that the original draft was right maybe you can say, we heard this and maybe we'd like to get your input on this. I just think that it's got to go back to the groups. Make sure that you're comfortable, that your draft, you're confident that you got your draft as right as you can, and then bring this back to your fellow other 3 commissioners to make sure that you have 3 votes for that line. That
I guess I'll ask because I wasn't on, well, I was on suitability, which was, a little smaller, but for you all that were on the other 2 working groups, what's your opinion as commissioners? Because you all know the work, you guys debated and you guys worked on this for so long. What's your take? Like, and we also have to think about staff and all the meetings that are already in play in terms of capacity. So I'm just curious, like, how do you all envision that going back and then coming back?
I would say based on, we kind of heard recurrent themes.
Yeah.
Right? So based on those recurrent themes, today's September 8th, our next meeting is the 14th. That's a short window, but we could work with the Grace and Kate to help us schedule those working group individual meetings where we can discuss those recurrent themes and bring them back to you. Now, the 14th is our licensing. So that's not going to lend time for regulation.
It's a big agenda.
The drafts. This is 14th is dedicated to licensing. That's why I was proposing the 15th. Because there's no time on the 14th to tackle this.
I wasn't even thinking that.
Yeah, that's why. Yeah, that's why I'm asking.
Yeah.
I'm asking.
Yeah.
Are we open, Madam Chair, to a meeting on the 15th, or is that still too soon?
I have to change something, which I don't want to change, but I will.
I think some of this is driven by when the working groups might be able to get back together and how extensively they want to go through reviewing the comments. I don't want to rush them so that we're in a huge public meeting still filtering through a lot of questions, but however long, I think it's important early next week to figure out when the working groups can reconvene. And I just want to be mindful, Andrew, if you're still there, Attorney Carter, what our deadline date is?
Yes, Commissioner, I would defer to Mercedes. I don't have the dates right in front of me, but we have set a pretty tight schedule that we have to follow. And Mercedes and I can circle back with the timeline when we have it.
I wonder, because I'm mapping this out in my mind, because of course I'll be in both rooms.
I hope that this is, I'm sorry to, this is.
No, I think this is valuable, and this is what we can speak freely, we can have this conversation. I am thinking about the practicality of this from my position because I have the 2 working groups. So I wonder, and I'm debating this, I just want to open it up, if it makes sense to dedicate one day to HCAs and then one day for municipal equity. And that way, at least I'm able to process the input and be able to, have a full conversation without conflating issues.
Yeah.
I hear you.
Yeah, but what I'm just trying to figure out is, so Monday the 11th is a holiday, just kidding. We couldn't notice that in time anyway, but I'm kidding, that's her birthday. So anyways, and we couldn't notice that in time anyway, but I'm looking at, because you have the most difficult burden in 2 groups. Is there a day where you could circle with the social equity and the HCA group, and then you kind of do this either, and again, I think it's really affirming, I think what we need to do is reaffirm what we've drafted based on the reams of paper and electronic and talk that we've gotten, and then either affirm or say, we'd like to hear from our fellow commissioners. So I think that the working groups make sense.
Yes,
and then we, but I think we're going to need an extra.
I agree, we don't need more time. So.
Yeah, I was just gonna say, like, not to sound too harsh, but I think Commissioner Roy, you said it a little bit, right? We've heard the themes, we've done the work in the working groups. This is the meat and potatoes of our jobs as policymakers and as commissioners. So I think that we really got to take a step back and step up too, to kind of say, all right, this is where I'm going now with the policy, right? I think our teams have provided the information. I think there's some things that we want some clarification on, right? For me, I want to go back and probably speak to someone on our team and say, hey, why did we pick that May 1st date, right? Kind of give me some clarification on that date. So for me, that's really the clarity that I want. That's just one thing as an example, but I think it's really up to you all and thinking of the time that we have right now, staff capacity, and then as policymakers, at this point, I need quiet time for the next 4 or 5 days, right? To sort of really kind of figure out what I want to come back, and really fight for, for lack of better words, in terms of some of those topics and kind of meet with some folk, because I don't sit in these groups. So that's just sort of a comment, but I think it's, as policymakers, I think it's time now for us to really pick sort of these policy points apart and figure out individually, but then also for folks who are sitting on working groups, take the temperature of your working group. I don't know how that is. I'm just thinking about time and capacity.
And the problem is we're up against a deadline that we shouldn't be here right now, but we're here right now. And I'm not happy with being here right now. So.
I just want to take everybody's temperature while we're able to do this in this setting. Are we in agreement that this draft is not done? There is more work to do, and we're not just going to submit it the way it is. We're going to.
I can't make that comment without dissecting everything first.
Okay, but I feel there's more work to.
But in that answer, the answer is it's not done.
Okay.
Yes?
Well, no, it depends. Like, in law school, it depends.
No,
I have to
my
go
point
through
is, if
everything.
you can't say, boom, Your Honor, here it is right now, that's what I'm saying. I can't say, boom, Your Honor, here it is, because I've heard some testimony that makes me want to understand, or at least dig in more deeply with the folks on the HCA group to understand, because I'm going to have to defend this. And I don't know if I have enough depth of knowledge or grounding in the right decision. And I want to push back, not that I'm questioning the decisions that were made. It's just, I want to understand, because I want to push back on the decisions you made, and you should be able to push back on the decisions that I made, so that we can then defend that to the public.
I mean, do you think, Madam Chair, that, I know our meeting is on the 14th, we'll probably be a little exhausted, but, we can either have a meeting on the 15th or the 19th. I mean, Bruce and I.
Well, we could, what I'm saying is we could kick it to the 19th. I did talk to Attorney Baker yesterday, and he said, yeah, you might want to, I mean, he and I were the ones who discussed this yesterday, about whether or not we were going to have enough time to,
And is Attorney Baker, Mercedes, and Andrew all on the same page?
I have no idea.
Yeah, I would want to know that.
Yeah. Well, what is do we know we don't know what our drop dead date is in terms of when we have to have the
Mercedes.
Yeah, it's October 11th. And
but what does the staff need from us? Like, if we were gonna go 18th, 19th, 20th, if we needed, my point is that I think that the groups need to, it could take an hour. If you go, I heard everything and we're good and I'm confident in my decision, then that could be a nothing meeting. But then we're going to come back as a full group, and then we're going to walk through these things. So my sense is that, we already have the 18th held. Maybe we could do HCA's that day, and then maybe the next day we do social equity.
The more I'm thinking about this and the more we talk about it.
I love when you do this.
I know, I'm thinking, my mind is starting, we spend enough time together now. I will speak for my own person in the way that I digest information. I want to comb through everything. And I need to be in a cave to really give all the comments the time, and then I need to then do my own legal analysis of the comments that we've received. So that it's causing a friction, though, if we're talking about also meeting with working groups, because it limits my ability to really go through and have a comprehensive analysis of what we've received in terms of comments.
But all I'm saying, well, so could we move it 18, 19, 20 to tie up whatever we need to tie up? We may not need those 3 days.
Well, I wonder, because we all have had an opportunity now to look at the draft. We've all received the comments. I feel like any changes would be in relation to the comments we've received. So I don't necessarily think that working group member commissioners have to present anything. We're having an open dialogue. So I'm saying I don't know if that working group idea makes
that's what I was trying to
sense.
That's what I'm trying to say. I guess what I was saying
You
something,
don't think that you want to go back to your working group and,
I think you
I
guys,
think these are now policy decisions that we're making.
okay.
That's what I think.
So then how do you, so take it back.
Okay.
How do you, I mean, I only thought it would be helpful for, well, you could just, I mean,
we have access, Madam Chair, right? We have access to, you all of us have access to members from the working group.
no, but that's what I'm saying, you and I can have a sit down.
Yes.
And that's not violating anything.
That's
Okay.
Correct.
So then we don't have to organize. but
That's
my
what I was
point
trying to
is,
think.
I
You
just-
are a working, you are a working group.
I know, but my point is,
We
I
can have a
think it would be
conversation.
good for each
And then we got to go
mayor
back and they,
to come back, to have a conversation, to say, are you comfortable? It did anything, I will tell you, there were a couple things that might have changed
Yeah.
my thinking.
Yeah.
About our working group, and I want to get some time to absorb and think about that.
Mhm.
So all I would suggest is that I think we definitely need to add the 19th.
I agree.
And possibly the 20th.
So the 20th will be an issue for me.
Okay.
And that's because I have the PVC. So I'm presenting, and that cannot be changed.
But we can do the 19th.
We can do the 19th, yeah. And I can do the 15th. So the 15th, 14th, 15th, 18th, and 19th, I can do all 4 of those days. If we need to.
Could you do remotely on the 19th?
I can be in person on the 19th. Either way,
I mean,
can do
what's the
remotely.
day that you're in, PVC is
The
Washington?
20th.
Okay. All right, I just want to make sure we have enough time. Okay, all right.
And then I also want to make sure I want to manage expectations. At this point, I don't want the onus to be on certain commissioners to defend, like to present and defend. It's like, this is,
yeah, true.
We're open now. Let's sort of have the conversation and go through it.
All right. So, all right, so let me work with Mercedes. And we'll figure out, we definitely will add the 19th. We'll notice that. And possibly the 15th. I have to move an appointment. I could even maybe do that. All right. I will work with Mercedes. I know he's telling us something, or she. Anyway, all right, we will get back to you by tomorrow, and there might be some staff people who are going, I don't want to tell them and I can't hear this, so, but know that at minimum, we're going to add the 19th, and then if we need to add either a half day on the 15th or a half day on the 20th, we can do that.
Can we talk about the 15th now?
Okay.
Just so that we can plan a little bit, and just on the 19th, just full transparency, Commissioner Stebbins and I were having a pretty much half a day social consumption meeting with our working group, but obviously we will reschedule that. But I think it'll be helpful for us to be able to plan a little bit, especially, you know, in terms of reading time and all that. So I think does
my preference for me on the 15th is to do a half day on the 15th.
What time? In the morning or the afternoon?
Morning, in the afternoon.
Like 10 to 1.
But it's going to be another few months, and I don't prefer.
No, it's okay.
But anyway.
What time to what time? Just
I mean, we could do, 9 to noon.
Would that be virtual or in person?
I think that we could do hybrid. If people don't want to drive all the way out here, I mean, I will come out here. So why don't we tentatively say 9 to noon? And is that enough cave time for you?
All of us?
Okay.
I know for everyone, yes.
We all need cave time.
Yes.
Nobody pick that term up, please.
Right. There's so many.
I got that from someone.
What's this? Oh, okay. All right. And then we're definitely going to notice the 19th. Whether or not we need it, we might be really good and get this all done on the 18th. But I just mindful of people's schedules. And then if the 15th, okay. I think that works. And what about the 21st? I'm just throwing it out there. What are people's schedules like on the 21st of September? Okay. All right.
I may not be here.
Okay. And she's looking at me.
Yeah, just because for the back end, after that gets done, the reflection of changes, so.
Go ahead, can you repeat that, Mercedes?
Yeah,
please?
after the vote, it's the changes on the back end. We have to make those to then the medical set of regs, and then it has to go through a review on our end. So I think we would, like, I know usually we had it scheduled for 3 weeks out. I wouldn't want to push it any further than 2 weeks.
Yeah.
If possible.
So I'm just looking.
I just, Madam Chair, I just have a question. Mercedes, when we, in Attorney Carter, when we real-time edit or vote, and we, let's say, change a concept, are we changing a concept, or are we creating the exact language, or is that our legal team will, so if we vote on a concept, let's say we heard the recurring theme of the deadline, that when they're going to start to enforce the HJs, right? So say 3 of 5 agree, okay, we're compelled to change it. That's a concept, okay? Do we have to real-time edit the verbiage as well, or is our legal department going to do that?
Yeah, so that was the process that we did during how we did it through the draft ones. And if Attorney Carter wants to come up, but we would then employ that same thing for the final regulations. Yes.
Go ahead, Andrew.
Yes, hi. So we are at the point now where we need regulatory language. So the commission will not be voting on concepts. They will be voting on the final regulation language,
Okay.
and then the language will be brought over to the medical regs as appropriate.
Okay. Thank you. And I'm assuming we have all of our attorneys with us, either remotely or in person, to help us through that process, the day of, while we real-time edit?
Yes, it will be very similar to the process that we engaged in July.
Thank you.
Madam Chair, can I just ask?
Please.
Just yeah. Just for, and I know the public's probably thinking like, wow, these folks are going through their calendar right now, but this is reality. I know we start at 10, and I know that whether it's hybrid, but I think, if it's hybrid and we could start at 9-ish or 9:30.
I will come in person.
Yeah, absolutely. And then, yeah, that's my only thing. And then I don't know I'm assuming you want to be here for the whole thing, Madam Chair, but on Friday, the 15th, if you have to go, maybe come back, or do you appoint, someone?
I mean, if I have to move it, it's just months before I can.
Okay.
You know what I mean?
I'm just thinking, just because we would have the rest of Friday.
Yeah.
And then all of Monday and all of Tuesday, because if we're doing real edit, Commissioner Roy, to your point, and conversation on a lot of new things, we're gonna need the Friday, we're gonna need the Monday, and we're gonna need the Tuesday. It's just a reality. We're gonna have to clear our calendars.
Again, everybody's going to have to be flexible. If I have to move something and move it out a few months, I'll move it out a few months. If it has to be done, it has to be done. So that would be my personal preference, but I am willing to suck it up. So that's okay with me.
Unless you can go and come back.
No, that's partial. No, I can't do that. All right, so tentatively the 15th, the 18th and 19th.
And Madam Chair, for the 19th, are we beginning at 9 or are we beginning at 10?
We'll, how about we notice it for 9? Again, I prefer being, I was just telling you, I feel much more comfortable doing this live, right? I hope we can do this in person as much as possible, because I just think that it lends itself to a better process. So if you want to notice, we can notice it for 9, but we can, depending on what people do, we can start at 10. And if we're very efficient on the 15th, then, we can do that. But I encourage everybody to be here in person as best as possible. I know Worcester is difficult for this part of the room, but anyway, it's.
We'll work it out.
Yeah, okay. Okay. So is that clear as mud, Mercedes?
Yes.
Clear as mud. Whew. Congratulations, everybody.
Thank you to the folks that are still here watching us, both virtually and in public.
Thank you to everyone who provided testimony today, because as I have said many times in my conference, that is such an important part of the process, and it does make a difference, and I just want to thank everybody who took the time to put their comments together and share them with us.
And we still have 153 people watching this. so
Madam Chair,
If anybody would like to make a final statement, Camargo, Concepcion.
Yeah, I have a quick comment for clarification, just for internal purposes. Are we all on the same page in terms of the working groups and the process, just so that our staff is very, so they understand what we're talking about? Because I know we kind of went in circles. So we're going to, as commissioners that were either on the working group, you all will reach out to your.
I have already asked her Commissioner Concepcion to meet with me and have a conversation about this anyway. So we'll make that happen, and you can have a conversation with Commissioner Roy. I assume that you may want to have a conversation about what's the word I want to say? The suitability.
Yeah. So we'll
I was trying to say sociability, I couldn't get the word, about suitability. So, again, I encourage all of the commissioners to, over the course of the next few days, have conversations, just say, how do you feel? What do you want? Did anything change your mind? And
challenge her quickly.
Yeah. Okay. All right. So are we ready to?
Yes.
Okay. Now I'm myself. So just looking through what I have. I just want to make sure I say the magic words. I don't know about the magic words. I don't. So anyway, I'm moving through. Is there, this is really terrible when I don't have my cheat sheets. Any additional business that was not posted before the meeting? Hearing none. The next meeting, as we have muddily stated, is going to be September 14th. That will be a regular Cannabis Control Commission hearing, and that licenses will be on that agenda. There may be one or two other issues, but that primarily will be a licensure day. And then we are tentatively going to be noticing the 15th, the 18th, and the 19th. We will notice it, but there will be some flexibility around what the hours are, and whether or not we need the 19th, we will make a determination at that time. So anyway, we'll get those things noticed so we can do it properly. Okay. Am I forgetting anything that I need to be saying for the agenda? Okay. So with that, I will entertain a motion to adjourn. Commissioner Camargo, will you make that motion?
So moved.
Commissioner Concepcion, will you gladly make that second?
Second.
Having been moved and seconded, I'll take a call of the roll. Commissioner Camargo.
I'll say thank you to the public, folks here, folks virtually, to our commissioners, Madam Chair, for running the meeting. Thank you.
Thank you.
Aye.
Thank you. Commissioner Concepcion?
Aye.
Commissioner Roy? Aye. Commissioner Stebbins?
Aye.
Chair votes aye. Unanimously, meeting's over. And again, thanks to all the participants and especially to all the staff who supported us. It was a difficult day.
I'm gonna go print out.
All right.